Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes.
Prosecutors are here, but I don't see Mr. Tucker. Some word from the front door. Has the state received any?
No, Judge, we have not received anything, Your Honor, based on multiple violations of your request to be a court on time. We're at the point where we're ready to ask for cases.
Yeah, I'm almost ready to issue it.
Our witness is here.
You want to tell him about Sidebar? See if he wants to go a little later today? That's what I'm saying. In other words, if we...
I take it the jurors are in the jury room.
Yes, we have all 14 judges.
Well, I'll give it till 1:15, and if he arrives beforehand, then let me know. If not, then I'll go from there. State versus Tucker. So I see you've graced us with your appearance, Mr. Tucker. Where were you when the case was set for 1 o'clock?
I was, again, on my way here, Your Honor. You know, again, I'm not the best judge of the traffic and everything in Key West anymore, apparently. I mean, I know I used to live here, but I also, I haven't been able to judge. I was actually planning on being here early today, Your Honor.
Well, this is the last time, sir, because next time I'm going to issue a capias. You will be taken into custody, and we will then know where you are, because we have 14 people who are here on time, 2 more over there, 1 more over here. These people. For about the 6th time, we've sat here waiting for you, and it now is interfering with the orderly process of this trial. I have been more than indulgent with every step of the way in your plodding along and showing up late and your cavalier attitude. Be warned, next time I will grant the stage motion for capias, and we won't have this problem anymore. So there's nothing need to be said other than if you need to leave earlier, whatever you need to do, be on time.
Yes, sir. Yes, sir. That's all I want to say. Yes, sir.
So in any event, we're back, and Mr. Johnson is here.
Yes, Judge, I'll get him.
Some water, please. Thank you. Okay, Mr. Johnson. Well, it's afternoon, but good day in any event. So we're back here in trial in State versus Tucker, 17 CF 841. You're back on the witness stand. We're going to bring the jurors here in a moment. I just remind you, you were sworn to tell the truth yesterday, and that oath remains in effect today.
Yes, sir.
All right. Bring the jury in, please. One more? Okay, well, you folks can have a seat while we're waiting for our final juror to join us from the jury room.
All jurors present in the court.
Okay, thank you. Everyone can be seated. Good afternoon, members of the jury. Good to see you all here today, albeit the beginning of the afternoon. As I told you yesterday, I did have a docket this morning, and we did accomplish what we needed to with those other cases, and so we're prepared to continue where we left off in State versus Franklin Tucker. The witness, Mr. Johnson, is here. He is still under oath, and we're going to continue with the cross-examination.
Thank you, Your Honor. May we approach the sidebar?
Yes?
Your Honor, I've talked to the state, and apparently the rest of the video that we were watching, they believe, I believe as well, is mostly, mostly not more interviews. It's mostly, just Mr. Johnson sitting in the interview room, which I don't think would serve the jury very well. So we're going to go ahead and forego the last, I think, 10 minutes of the video.
Okay.
Okay, and in that case, I think we move on to, okay, let me grab this. Okay, Mr. Johnson, let's see if we can recap a little bit here. Now, we went over your interview with Captain Phelps, pretty great length. There's a couple other things I wanted to go over before we go ahead and excuse you. Now, you did say that you didn't go anywhere else prior to the treehouse that day and the beach. Is that it?
As far as I can recall.
17th, right?
As far as I can recall.
As far as you can recall. You don't recall going to CVS that night?
I do not.
And you said that you would be surprised to learn if they had a picture of you outside of CVS. Is that correct?
This is what I said, correct?
So you don't recall going there, don't remember. You don't know about the picture they took of you. Okay. Would surprise you to learn that that's actually just prior to the incident going down, just prior to the crime?
Yes.
Now,
Surprise me, yes.
okay.
Mr. Johnson, could you keep your voice up, please?
Yes, sir. I apologize.
And let me go ahead. Yeah, apparently the mic didn't have a battery yesterday, so I want to make sure everybody hears me loud and clear today. Mr. Johnson, you know, if, again, you saw a picture of you outside the
Objection
CVS,
asked and answered.
I said, if he saw it,
Okay, let's hear the question, so go ahead.
okay, just prior to the crime taking place, what would that picture mean to you?
I don't know. I don't recall it. I don't recall going into the CVS.
Oh, you don't recall. You know, what I asked is, what would that picture mean to you? You know, did you say yesterday? I seem to remember you saying something like, "Get a lick" or something like that, and you described to us what that meant. Hitting a lick. That's what it was.
Yes, I described that.
Okay. And what is hitting a lick again?
As far as the vernacular, as I understand it, it means to steal something, to take something, to come up from a broke position.
Okay. And is that criminal terminology?
It's a vernacular, slang vernacular.
Okay, but is typically used in criminal terminology.
I
Hitting a lick.
wouldn't know if that's what that was in reference to or not. No, that's just slang as I understand it.
Okay. But you understand it as a come up, right? To get something.
I believe I explained that, yes.
Okay, good. Just making sure we're clear. Now, do you understand the vernacular of casing a joint?
Yes.
Okay. Do you understand how a picture of you in CVS just prior to the crime could be considered casing a joint?
No.
I'm going to object to the
I'm
question.
going to sustain the objection. Sheer speculation.
No. Mr. Johnson, again, you also said that, what is it? Let's take a look here. Make sure I'm correct, because I may not be. Let's take a look. You said you emptied your truck, correct, as soon as you got up to Big Pine.
Yes.
This is when you discovered your Foot Locker.
I didn't discover my Foot Locker.
No, somebody put something into your Foot Locker. I'm sorry.
After I emptied my contents in my truck into the residence where I was residing, yes, this is when I discovered
Okay.
the backpack in my Foot Locker.
Backpack in your Foot Locker. And you have no idea how it got there.
No, I don't.
Let's see. And when was this Foot Locker out of your possession?
Several times.
Okay. Well, looking at the dates again, did you, you said that I helped you put your Foot Locker into your truck. Do you remember what date that was?
the date that I left.
Okay. So that would have been on the, what, 22nd? Oh, I'm sorry, no, it wouldn't have been on the 22nd. That would have been on, what? Yeah, that would have been on the 21st. Is that correct? Did that sound about right?
That sounds about correct, yes.
Okay, good. Because you said the day of the raid, right?
The day after, like the morning after, yes.
Morning after, so that would have been the 22nd. I'm just trying to keep our timeline here. Okay, so 22nd is when you moved, and supposedly I helped you move this Foot Locker. I seem to remember, let's go with my memory. Now, after the raid, I wasn't there, correct? I was at the police station.
I guess they took you into custody, yes.
Okay. Yeah, well, actually, you wouldn't have known where I was, that's true. Okay, but I wasn't there, right?
No.
Okay.
Not when I got back, no.
Okay, and did I arrive sometime later?
Early that morning,
Early that morning. Do you remember about what time?
no.
Okay.
Before sunrise.
Before sunrise. Okay. And do you remember me saying anything to you after I got back?
No.
Don't remember anything. Did I have to wake you up to open the door?
No, I don't believe so. I don't remember.
Okay. You did have the only key, correct?
No, I didn't.
Well, you said Rory Wilson had a key.
Yes.
Okay, but, Rory was, to your knowledge, was Rory Wilson, man, was he actually still in jail at that point?
Yes.
Okay, so he didn't, again, obviously his key would probably be there with him, correct?
I don't know.
Or, again, would I have access to it most likely?
I don't know.
Okay. Actually, let me rephrase this. This is too much supposition.
I thought you covered this yesterday. This is all repeat testimony.
Well, I can't say with certainty, so we certainly
Thank you.
aren't going to cover what has already been asked and answered, but
Right.
thus far I can't say with certainty that's the case.
Thank you. Let me go ahead and get this a little bit better. 'Cause I'm not wanting to do that. Let's go here. All right. This one. Okay. Let's see what we got here as far as recaps. Okay. We've already covered the routes. We've already covered the knowledge. Okay. Again, could you do you happen to remember your phone number from that point in time?
I do not.
Okay. Again, did your lawyer again make you privy to any of the discovery concerning phone records?
No, not concerning phone records.
Okay. Now, in the video, we did see the detectives, and if I remember right, did you? I would imagine you saw with us the detectives discussing your phone calls with Rory Wilson.
Yes, I remember that.
Okay. And they discussed how your phone calls were right around the time of the crime, correct?
I don't remember what time the phone calls were, no.
Okay. You don't remember when we watched the video what times they were talking about?
No.
Okay. Would it surprise you, again, I think you said your answer, I'm trying to clarify here because my memory may be messed up. I think you said that you told the detectives, did you tell the detectives something like, we were just talking, or, we're just talking or something like that?
Again, I don't remember the conversation.
Okay, not even after the refresher we had?
No.
Okay. I don't know if we want to go and repeat the video, but I don't know. We may have to. Now, let me converse with the state, if you wouldn't mind, for just a second. Take a look.
Yeah.
Let's try this again. Mr. Johnson, do you remember watching the video yesterday?
Yes.
Okay. Do you remember the section where the detectives are talking to you about your phone calls with Rory Wilson?
Yes.
Okay. You don't remember the context of that conversation, or do you remember what you said in that video?
I don't remember what the phone calls were about between me and Rory Wilson. And I do remember in the video me saying the same thing.
Okay. You saying the same thing in there?
Yes.
Okay.
But I don't remember what the context of the video, of the phone calls were. I still to this day don't remember.
Okay. But you do remember the context of the video, right?
Yes, of course.
Okay.
Correct.
And you do remember the detectives asking you, or again, asking you in reference to the time frame of those video or of those phone calls.
Yes.
Okay. And how it is around the same time of the crime, before and after.
I remember the video, correct, yes.
Okay, so you remember them saying that?
Yes.
Okay, good. Okay, and now you said that you were in a hurry to get out of there, right? You wanted to get out of the warehouse, get away from myself and Mr. Wilson.
Yes, I said this.
Okay, and so you were in a hurry to get out of there.
My understanding of the word hurry is to move as quickly as I possibly can.
Well, and you agree on that. What
Right.
would you consider as quickly as you possibly can, considering that, again, you had learned that it was a homicide?
The time frame references between here and now, I really don't know how to answer that question for you.
Okay. Would you consider, again, you said you left the crime scene because you were scared and wanted to get away from the situation. I'm asking you, how quickly would you want to move out of the warehouse where you were still being subject to myself and Mr. Wilson, still being there?
As quickly as I could.
Okay. And as quickly as you could, would that mean a week, a month, a year?
Unfortunately, I'm not a fortune teller and I can't see the future, so I have no idea how long it was going to take me. I had no clue how long it would take me, and I had no specific time frame to reference to how long my hurry should take.
Okay.
I'm sorry.
Okay, would it surprise you to learn that the day after the crime, you had about 10 phone calls with Mr. Wilson?
No.
Okay, doesn't surprise you?
No, I don't remember these phone calls.
Okay, you don't remember those phone calls?
No.
Okay. Again, you moved out, was it the 22nd we agreed? Okay, so the 22nd, so the 17th to the 22nd, that, my count, that's what, 1, 2, 3, 4, 5. So 5 days, and you moved out, correct?
Correct.
Okay. And what were you doing in the meantime?
What people do to try to get out of where they're at.
Okay. What did you do to try and get out of where you were at?
Scheduled appointments with individuals that my girlfriend and I could acquire for me to get work, perhaps shelter,
Okay.
residence. These things take time.
I would understand that, and under normal circumstances, yes, that would probably be the case.
Normal
What I'm asking you is,
circumstances.
under the stressful circumstances that you were in, does 5 days seem like a long time?
Judge, I'm going to object to the question.
This has already been, we've already gone over this multiple
Okay.
times. I'm going to sustain
Okay.
the objection.
Again, how many conversations did you have with Rory Wilson after the crime?
I don't remember.
You don't remember? Do you remember any? You don't remember talking to him at all?
No.
Okay. And, let's see. You did. You said you didn't see Rory Wilson after that, though, correct?
Okay, what?
You didn't see Rory Wilson after the crime.
Yes, I did. I
Oh, I'm
walked with
sorry.
him back from Tom Thumb.
Walked back with him from Tom Thumb, spent the night with him there, correct?
Yes, the next few
Partying.
nights until the raid happened,
A
yes.
second, partying, correct?
For one night, yes.
Okay, and does that seem like the actions of somebody who's scared?
Do you understand what the actions of somebody who's scared are?
You have to just answer
I would like an
the,
answer.
not with a question.
I don't know how to answer your question. Yes,
That's
no,
all you need
yes.
All you need
Yes.
to say, if you don't understand the question, you don't know how to answer it, Just say that.
I'm just trying to, I'm trying to
Yeah,
understand.
we know, so let's just go on with between the two of you, question and answer. That's what we want.
I would like to understand, Mr. Johnson, why, if you were afraid enough that you took off and, left the crime scene the way you did, that you would sit there and party with these people when you got back.
Objection, Judge.
Yeah, I'm going to sustain the objection.
Okay. All right. So we established that, the very first, the crime afterwards.
Okay, I'll overrule that, but
Okay. Thank you. All right. Mr. Johnson, okay, after the partying of that night, again, did you see Mr. Wilson after that?
I saw him up until he was arrested at the raid.
Okay. You saw him up until,
Periodically, like, coming and going, yes, as well as you.
did you have any conversations with Mr. Wilson?
In passing, I don't remember specific conversations, no, but I'm sure that we spoke.
Okay. And you said that he held on to some of your belongings for you while you were in jail. Is that correct?
I said that he said that.
Okay. And did he, in fact, hold on to some of your belongings while you were in jail?
If you want to call it that, yes.
Okay. And I don't know. What would you call it, Mr. Johnson?
Theft?
Okay. So you're saying he stole from you while you were in jail?
That was my belief, yes.
Okay. And again, did you inform the police that he stole anything from you?
This is what I informed them that could have happened. I don't know if it was him or not.
Okay.
The investigators are the ones who were determining that. This
Okay.
was the only information that I could give them, is what I believed from what he told me and where my belongings were. This is what I told them.
And you told this to the police when you filed your report for robbery, not
That
after,
day.
not after
The day it happened, with the individuals, the officers that came
Okay.
when I called the police. That's
And-
who I told this to.
And you told them that Rory Wilson stole from you.
I told them I believed that the individual on the steps stole from me.
Did they question Rory
The
Wilson?
gentleman objects to the relevance of this line of question.
I'll overrule the objection.
Thank you. Did they question Mr. Wilson at all?
No,
Okay, they didn't question him. And did you, in fact, ever get any of your items back from that?
no,
Okay,
not the ones I reported stolen, no.
okay. But that was the guys they used when they brought you down to the station, correct?
Correct.
Okay, but you didn't get any items back?
No.
Okay. And you said, again, that you emptied your truck. Okay, when they went to search your truck, if you emptied it, why would there be items still left in there?
When my truck was searched by the police, this was months after I had been arrested. Months after I had been arrested. My truck had been towed from said residence and packed by whoever didn't want my stuff in their home anymore into my truck to have it towed to Mr. Martin Ochoa's residence. That's where the search was conducted, not at the time or point of my initial contact with police.
So to be clear, just to be clear here, your truck got towed from the residence you were at to Mr. Martin Ochoa's home. Is it a home or is it his business or something?
His home.
His home. Okay, so it got towed to his home with your belongings in it, correct?
Yes.
Okay. And you said this happened, the search happened months afterwards.
Yes.
Okay. Now, did anybody else, to your knowledge, have access to your truck at that time?
Everybody that possibly wasn't me. I was in jail.
Okay. Okay. When the tow truck actually took it, did you have the keys, sir?
The keys were in my property. I did not have them, no.
You didn't have access to the keys?
No.
Okay, so that would mean the police had access to the keys or somebody else?
They were in my property.
Okay. And we did have the privilege of talking to former Detective Malone, who conducted the search on your truck. I think she described it as a lot. Does that sound correct to you?
A what?
A lot. You said it was Mr. Ochoa's home. She described it as a lot. Was it a lot?
I don't know. I've never been to his home.
Okay. And did you ever find out what happened to your truck after the police searched it?
It was repossessed by the bank.
It was repossessed by the bank. Okay.
Correct.
Okay, so you have no idea what happened to it after that?
Correct.
Okay, good. Now, again, amongst your belongings that they brought out in the search was, I believe, an extensive knife collection, if you want to call it that. Yeah.
Yes, it was.
Extensive. And if I seem to remember correctly, you like to take care of your knives. Is that correct?
I'm a blade collector, of course, yes.
You're a blade collector. Okay, and do you like to sharpen your knives and oil your knives and such things? And again, I'm not a very knowledgeable person in this thing, but I seem to remember that was something you liked. Is that correct?
Yes.
Okay. And would it surprise you to know that the residue from those things can be detected? The oils, the stone.
The stone.
And when you sharpen the blade.
Yes,
Okay.
I guess.
Okay. Well, again, now you said that the knife that has been used in this crime, you said that belonged to me, correct?
No, I did not.
I seem to remember you. Who did it belong to then?
I don't know.
Okay, you don't know.
No.
Okay. Okay. I'll save that one for redirect. And again, with the knife, you seem to have great detail when describing it in your interviews. How familiar were you with that knife?
Familiar enough to think that it was a dive knife.
To think that it was a dive knife. Did you know the color? Did you know the handle? Did you know the blade?
Yes.
Okay, all of those things.
Yes.
Okay, and again, how many times have you been in contact with that knife prior?
Once.
Once?
Yes.
Okay. And how long a period of time were you,
I don't recall.
Wait. Let him finish the question.
how long a period of time were you in contact with this knife?
I don't recall.
You don't recall?
No.
But enough to know the details of it, correct?
Sure. I'm interested in knives. I try to remember them.
Okay. So, but it doesn't take very long.
No.
A cursory glance, maybe?
It depends.
Okay. Okay. Let me go ahead and we're going to go ahead and, subject the witness to recall, I'll go ahead and let we can end this and go for redirect, Your Honor.
Okay. Well, when you say subject to recall, you're talking about in your case? Is that what you're saying?
Yes, sir.
Mm-hmm. Well, I guess the cross-examination is concluded.
It's concluded.
So, State would like redirect examination?
Yes, sir. Yes. Judge, before I get started, I do want to move into evidence the video that the jury watched during the cross-examination. I have it marked here. So much better. Okay, I have it marked as P as in Papa. I'd seek to move this into evidence.
I take it there's no objection?
No, sir.
All right, admit as the State's next in order. Number, what is it?
13.
Third? I thought we already had third.
Oh,
I thought we were up to 15. All right, admit State's 15.
All right, now the state's 15 is in evidence. Just put that in, please. I'll be referring to some portions of the jury's correct, Judge. That's why I want to make sure it's queued up. All right, Travis. A couple things I want to clear up here.
Yes, sir.
You said, way back at the beginning, you said you came to Key West, you actually advertised, was it on Facebook?
Yes.
And you advertised for what?
For a position as a painter.
Okay, and did you receive calls through that advertisement?
I did.
All right. Can you say for sure whether you did or did not receive a call from this defendant during that early time in Key West?
I cannot say no.
Is it possible you received a call from him not knowing who he was or not knowing what your future with him would entail?
It's possible.
Okay. So the first time you remember meeting him is when?
When I got out of jail.
And you were living at the warehouse?
Yes.
And when you first met him, where was he?
At the warehouse.
Was he with anyone at the time?
I was with Detroit Wilson, Rory Detroit Wilson.
And that's the other one that's involved in this plan this night of this
Correct.
robbery. Now, Travis, you agreed to get involved in this, I guess, this plan, and your expectation was to what? What did you expect to get out of it?
Gas money for my truck.
And at that point in time, are you familiar with the legal concept of the principal theory?
At this time, no.
Did you know that you could potentially be held liable for anything that happened inside of that treehouse, even though you were only the getaway driver?
No, sir, I did not.
Now, the plan, to be clear, was to go in there to commit a robbery. Is that right?
Correct.
And again, what was the goal in going into that treehouse that was discussed between you, this defendant, and Rory Wilson?
To get the money in the crack that the resident had.
And again, that lead came from somebody at the Burger King. Is that right?
Correct.
Now, you said several times that lead was brought back from Burger King by Rory Wilson, right?
Correct.
And then at one point, I think on one of the tapes, you said something about Tyrone. Is that right?
Correct.
Was that a misspeak on your part?
Yes, it was.
As you sit here today, do you remember who brought the lead back to the
Yes, I do.
to the warehouse?
I do.
And who was that?
That was Rory Wilson.
All right. He brought the lead back, and who did he share that lead with?
Mainly with Mr. Tucker.
And at
And me.
And you.
Yes, I was in the room.
Okay. And at some point, you got involved in the plan to go over there.
Yes, I did.
Now, there seems to be a little confusion on the cross about how many trips over to the treehouse were made prior to the actual robbery. So let's be clear. You had testified that you guys went over there and did, I guess, for lack of a better phrase, a drive-by. Is that accurate?
Yes.
And after the drive-by, were there people or cars at the treehouse at the time?
Yes.
And you guys went back to the warehouse?
Yes.
And when you went back to the warehouse, what was the purpose in going back to the warehouse?
For clothing.
And about how many minutes later, if you can estimate, did you guys head back over to commit the actual lick?
I feel like about 5 to 15 minutes. I'm not 100% sure of the timeline.
Okay. Now, yep, that's it. Okay, good. I retrieved item number 7, it's in evidence from the clerk. Chris, let's go into the electric one. Or let's go into the other one first, the Cosme. David, if you could help me. Which ones? Yes, I got it right.
Which video is that?
All right, Chris, let's go to 1943. Travis, it's coming up here, 1943 and 22 seconds. Right. Perfect. Okay, right there. Is that consistent with your truck pulling over the treehouse?
Yes, sir.
All right. And is that consistent with what happened on the day, November 17th of 2017?
Yes, sir.
Now, on this is your initial approach. Is that accurate?
Yes, sir.
Did you guys stop or did you continue going after that initial approach?
I continued going
And again, if you can refresh the jury, why did you do that?
because there was somebody there.
All right.
Or is this is the first one? No, this was the initial drive-by.
Not the initial, right?
This is the one before I stopped and they got out.
Okay. So after leaving the warehouse, when they were dressed in black and with weapons, this is your first approach after you left the warehouse?
Yes, correct.
Now, if you look to the right of this boat, between these two boats, back in this area, we see your truck go all the way through. Is that correct?
Yes.
Now, there's some talk here. There's a glare there, right, on the front of this boat?
Yes, correct.
Do we know where that glare is coming from?
No, sir, we do not.
It's obviously not your headlights, right?
Obviously.
I mean, where's your truck at this point?
Not there.
Is there a glare coming from this window?
That's a light
A light?
yes, that's a street lamp at the CVS.
Okay. But the glare that we're seeing there, is it fair to say that's not coming from your truck?
Yes, this is fair to say.
Because your truck at this point is where?
Not there.
Okay, not there. Where is your truck? Tell the jury where your truck is right now.
Driving around the block.
All right, fair enough. Okay, Chris, if we can go to, actually, just let it play. According to my tax code, it's gonna be 1945. Chris, if we can just advance 1945, that'll.
Your Honor, may I move up a little bit closer so I can see here?
Yes.
Thank you.
And Travis, I'm gonna again have you focus your attention to the left of that big boat that's in the middle of the frame.
Yes, sir.
Pause. Do you recognize that?
Yes, sir.
What is it?
My truck.
Okay, now, a minute and a half, 2 minutes later, right?
Correct.
Minute and a half later?
Correct.
All right, would this be consistent with you reapproaching the treehouse after the first drive-by?
Correct. Yes.
Chris, if you just play for me? Now, focus your attention over here. Keep going. Pause. Can you tell for sure where your truck is at this point?
100% no.
Now, there's a couple different glares going on here, right?
Yes.
Chris, if you can back up for just 3 seconds. Okay, number 1945. Is that you there?
Yes, sir.
All right, what's what we just saw? Right, go ahead, Chris. Focus over here, Travis, if you would. We can see a flash from your headlights as it approaches. Is that accurate?
Yes, sir.
But do we know where the truck is stopped at this point?
No, sir.
Kind of hard to see in this video?
Yes, sir.
Now, we still see a light going on here, right?
Yes, sir.
Is that coming from your headlights?
Probably not, sir.
Okay. Now, your testimony is that this defendant and Wilson got out of your truck, right?
Correct, sir.
Does that consist of what we see there?
Yes, sir.
All right? And that's at what time now? 1945 and 47. And Chris, will you take us to 1951, please? Travis, if you look over here, do you still see a light over here?
Yes, I still see a glare.
Where's your truck at this point?
It's still sitting right there.
Is it in, can you see this frame or not?
No, sir.
Now, we just saw somebody run up the hill. That's, we said before, that's a Quinn, correct?
Correct.
Right there. And again, who do we see running there dressed in black?
That's Mr. Tucker.
The defendant.
Yes, correct.
And you didn't see Wilson leave?
No, sir, I did not.
All right, Chris, I'm done with this one. Let's go back to the clerk. All right, Chris, that's one. All right, perfect. All right, I'm going to bring your attention to some times here in a minute. Now, all right, Travis, so we've covered the videos from the night of the event. I want to go to what was going on with you after they brought you down to the station under the guise of looking for your items from your truck.
Yes, sir.
Now, you got to the station that night, right?
Yes, sir.
Initially, when they switched the script on you and they started asking you questions about what happened at the treehouse, were you surprised by that?
Yes, sir, I was.
Did it catch you off guard?
Yes, sir, it did.
And initially, during your conversation with them, did you come clean right away and give them
No, sir, I didn't.
own up to what you had done?
No, sir, I didn't.
What were you doing?
I was backpedaling. I was scared. I was processing in my mind what avenue I wanted to take.
And so, as they asked you questions, were you being 100% truthful with their answers?
No, sir, I wasn't.
Were you trying to mislead them or diffuse them?
A little bit, yes.
Were you worried about minimizing your involvement in this crime?
Yes, sir, I was.
Again, at this point, were you familiar with the principal theory?
No, sir, I wasn't.
Were you familiar with the idea that you could be held accountable for everything that happened, even though you were in the truck that night?
No, sir, I was not.
As they questioned you, did they start to confront you with more and more evidence that they had in the case?
Yes, sir, they did.
Now, you specifically testified that Phelps put it together, right?
Yes.
She's the detective or the lead that was in there?
She was the captain, yes.
The captain, okay. And you said on, I believe it was on direct and on cross yesterday, she nailed it 100%.
Very smart detective, yes.
When she went through the events with you, were you surprised at how close she was to the truth?
Yes, sir, I was.
And as she talked to you, and we saw it in the video yesterday, did she present you with her theory of what happened?
She did.
Okay. Now, let's go, Chris, if we could, to 2019, please. It's at 2019. I'm not sure which one it's going to come up on. Maybe that one. Okay, no, we got to go to 20. and hour 20, 19 minutes.
I mean, I'm like full time. With that one key. And key was good. Yeah.
And do you want some water?
And my field, we've been able to verify. This guy, stop up in his head, but there, we'll get out. You just, whatever. Okay. I don't think that is okay. Just look like a, all that you see, I don't know. Yeah. Once you get to my city truck, it'll leave. But, raise it, man. Just like by itself. Not yet. We need to look at the last one. Like services, you want to show how would
Okay, Chris, go ahead and stop.
20, 10, spines, and fines.
And pause, Chris.
When you saw Tyrone,
Now, we're at the point of the interview where you were talking more clearly with Captain Phelps. Is that fair to say?
Yes.
Are we at the point where you have decided time to come clean?
Yes.
What brought you to that decision, Travis?
Actualization of the fact that somebody was dead and I was responsible, and you know, that I wanted to make sure that this was resolved.
Now, at that point, you decided time to own up to it?
Yes, sir.
And is that what we saw in the video yesterday where you got very upset? I think you had a moment where you really got overwhelmed?
Yes.
Why is that?
Actuality, reality slapping me in the face.
The reality is that you were involved in an event that turned into a homicide.
Correct.
Scary stuff, right?
Yes, sir.
Now, you're talking to Captain Phelps, and she's asking you about the knife, right?
Yes.
Did she tell you what the knife looked like?
No.
Did you tell her what the knife looked like?
I did.
I mean, they knew a knife was involved, right?
Yes.
The guy had been stabbed to death, right?
Yes.
So when she asked you about the knife, did you describe the knife?
I did.
And how did you describe it?
I described it the way it looked, the way it is.
Go ahead. Black and red?
Black and red with a serrated edge. Yeah, black and red with a serrated edge and a smooth edge on one side and a silver pommel on the bottom.
Had you seen that knife before?
Yes.
How many times did you see it?
Once or twice.
Where did you see it on the night of the treehouse stabbing?
And I saw it in the house and then I saw it in Tucker's hands.
Tucker's hands.
Yes.
You guys sit right there.
Yes.
It's in his hands when he came out of the house.
Yes.
Dressed in black?
Yes.
You're telling Captain Phelps. Now, when Captain Phelps was asking you about details about the knife, did she show you the knife?
No.
All right. You told her what color was the handle.
Black and red.
All right. What about the blade? Did you tell her about the blade?
Yes, I did.
What'd you say?
Serrated on one side and sharp on the other. Smooth on the other.
Serrated on one side, sharp on the other. Throughout your interview with Captain Phelps, what did she tell you she wanted from you?
The truth.
The what?
The truth.
The truth, right?
Yes.
She say it more than once?
Yes.
Matter of fact, at one point, doesn't she say to you, tell us what happened, and your response to her is what? You just said it,
Yes.
right?
Yes.
When you said you just said it, what were you meaning when you said that?
I was meaning that she knew the truth. She had, through her theory, for lack of better words, nailed it. And
And
she
what was
just
her,
said it.
do you recall what her response was when you said you just said it?
She said she needed to hear it in my words.
She wanted to hear it in your words, right?
Yes.
You tell her what happened. And then you went and you started telling her exactly what happened. Is that fair?
Yes.
At 2020, Chris? Yes, please. And I'm going to let it play for a couple minutes because then there's a couple things within the next 2 minutes I want to talk about, okay?
Do you know who killed the guy? Did they ever tell you? If one person that was stabbed, who would you think would have done that?
Pause, Chris. She asked you if you knew who stabbed the guy, right?
Yes.
And she asked you if you had to guess, which one would you say?
Yes.
And what was your answer?
I didn't know well enough to develop a guess. I didn't know either one of them well enough to know who had done it.
Did she give you the name of Tyrone Tucker, or did you offer the name?
I offered the name because she said that I knew who did it, and I think I offered it in the form of a question.
So you offered the name of Tyrone Tucker, not Penny Phelps.
Correct.
You're the one that brought that name into this narrative. Is that fair to say?
Yes, sir.
Not Penny Phelps.
Correct.
So when the defendant says this was her narrative that you simply endorsed, that's not accurate, is it?
No, sir, it's not.
Go ahead, Chris, play. Chris, why is the video not?
Did you see kind of what clothes and clothes that like that?
Okay, the video is not buffering, I'm told. It's the same as the audio, but the audio is what's important to me at this point. The jury's going to be able to look at this. It's in evidence. So let's just go with the audio. Chris,
Your
go
Honor,
to.
can we sidebar for a second?
Yes?
Chris, if you could, you go ahead and hit play then.
Did you ever see more taking a photo that you wanted for them? Like in a bag, trying to get rid of them? They just started to get rid of it first. Okay. And so it's $250. That's pretty messed up, guys. Pretty messed up.
Chris, can you turn it up at all? Okay.
Before the robbery happened, what did you think was going to happen if you told them, no, we're not doing it? What did you think was going to happen?
You know, the fact that they're talking about grief and something like that, they can't trust me, they don't, you know what I mean? Now I've got to worry about really sleeping in that place. I was nervous. I felt like I needed to
Mr. didn't go along with it, what do you think was going to happen?
You know, with all my stuff would have been, you know, stolen, whatnot, you know. Maybe, I don't know, it was not.
Okay.
Next piece.
Yeah. So when you were saying you were in prison last year, you were afraid. More than, did you know what was going to happen? Okay.
I figured like I just needed to go along until I could get an opportunity to get out there safely.
You're a sick person now.
Yeah, but how safe for me is working and where my stuff is to make it earning my living and going along. I don't have to.
Excuse me, you building up to a question here, or just?
Yes, Judge.
Okay.
All right, Chris, go ahead and pause. I was hoping to get to the part, Travis, but let's just talk about it. At one point, you offered to draw a map. Is that accurate?
Yes.
And what was that map? What were you requested to draw? Or what did you request to draw when you wanted to draw a map?
The route.
And did Captain Phelps tell you what route you took?
No.
Did you tell her what route you took?
Yes.
Matter of fact, at some point, she says something on the map, and you correct her, don't you?
Yes.
She's pointing in the wrong direction, and you actually corrected her as to which direction your truck was going.
Yes, sir. I believe it was.
All right? At that point, is this your narrative or her narrative?
Mine.
Yours, right?
Yes.
You gave a detailed description about the planning of the robbery, correct?
Yes.
Did they know about the details in the plan?
No, sir.
Where'd those details come from?
They came from me.
What about the details in Rory Wilson's mask? Is that something they provided to you?
No, sir.
Where'd that information come from?
They came from me.
What about the gaiter that this defendant was wearing? Did she provide you with that information?
I'm
No.
sorry, what's the objection?
If there's been established that I was wearing anything.
Well, I disagree. That might be a point of contention, but it's a legally cognizable question, so I'll overrule the objection.
Let me ask it again, Travis. So the gaiter that this defendant was wearing, did Phelps give you details on that?
No, sir.
Where'd that information come from?
It came from me.
Now, describe the defendant. He looked different back then, 6 years ago. Is that accurate?
Yes.
Tell the jury about how he looked. Did he have a bigger goatee, smaller goatee?
He had a goatee about this long. Straight.
Long.
Long.
All right. Did he have a full set of teeth?
No.
And the gaiter that he pulled up, does that cover his goatee?
Yes. Yes. I apologize.
The knife you gave the details on, is that fair to say?
Yes.
Now, the money that you got, you said it smelled like perfume.
Yes.
Is that something that they told you, or is that something you gave to them?
Something I gave to them.
The defendant brought up the scenario about April Walker. Again, who was April Walker?
Rory Wilson's girlfriend.
Rory Wilson's girlfriend. Was she living at the warehouse as well?
Yes.
The defendant asked you about these threats and the timing of these threats. Do you remember on cross?
Yes.
When you left for Big Pine, was April still in that warehouse?
Yes.
And you said to the defendant when he asked you, she didn't appear to be nervous or scared, right?
No, sir.
I believe that's what you testified to on cross.
Yes.
Now, you were up in Big Pine for at least a day, then they brought you down to the station, right?
Yes.
In that tape, when we see Captain Phelps come into the room and tell you that April Walker's nervous and scared, is that before or after you left the warehouse that morning?
After.
After, right?
Correct.
So when you left the warehouse, had April Walker received those threats?
Not as far as I know, no.
When Captain Phelps came in the room, what did she say?
She said that April had received threats.
Had just received threats.
Just.
Defendant also asked you about whether you saw blood on on him or on Wilson that night, right?
Correct.
What color clothing were they wearing?
Dark, black.
Is it easy to see blood on dark black clothing?
No, sir, it's not.
Were you looking for blood on them that night?
No, sir, I wasn't.
Had you suspected that somebody had been stabbed to death inside the treehouse?
No, sir, I hadn't.
So when you walked with Wilson back from that CVS, I'm sorry, I apologize. When you walked with Wilson back from Tom Thumb, were you looking at his body to see if there was blood on it?
No, sir.
When you and this defendant were in the warehouse right afterwards, and this defendant was mad at you for having left him, were you looking at his body for blood?
No, sir, I was not.
Again, what color clothing was this defendant wearing?
Black.
After you left, that place in Big Pine, you said your truck was empty when you left, right?
Correct.
And you had unpacked the stuff into the house, right?
Correct.
Then the police came and looked at your truck, right?
Correct.
And then they invited you to come down to the station and look at this other stuff they had, right?
Correct.
Did you ever see your truck again after that morning or that day?
No, sir.
So when you left Big Pine, you never saw that truck again?
No, sir, I didn't.
When you left Big Pine, was the truck empty?
Absolutely empty.
So how did you find out that somebody had taken all your stuff out of the house and put it back in the truck?
When I received the search warrant affidavit.
Okay. Were you surprised to find that all that stuff was in your truck, or did you figure that's what was going to happen with your stuff?
I figured it was, I really didn't know, but yes, I was surprised to know that it all had been piled into the bed of my truck.
Now, you are a knife collector, right?
I am.
You had a pretty extensive set of knives. Is that fair to say?
Yes, sir.
And were those knives back in that truck again after they cleaned out the house that you were staying at?
Yes.
Or that you were going to stay at, right?
Yes. Yes, the knives were in my possession when I went to that house, correct?
Okay. Now, when you finally decided to own up to your involvement, that's when you, I guess, came clean with the detectives, right?
Yes, sir.
Did you do that before or after they showed you the videos from the electric company and from the Cosme Marina?
Before.
So those videos that this jury has seen, you were not shown those until after you gave them your statement. Is that accurate?
Correct.
It's been 6 years. Can you still, in your memory, clearly see this defendant running from the court, the treehouse that day?
I can.
The defendant asked you today, you wanted to get out of there quick, right? You were scared, you wanted nothing to do with this, right?
Correct.
But you still wanted to get high, right?
Of course, that's the insanity of addiction.
So you weren't about to leave until all the drugs had been smoked, at the very least, right?
Correct.
Let's talk about these deals. You came in and you gave statements, right?
Yes.
And we just went through the one that you gave to the detectives back in 2017. Is that fair to say?
Correct.
We played that pretty much in its entirety yesterday, right?
Correct.
Now, in April of 2022, you were approached again about potentially becoming, or potentially entering into cooperation with the state.
Correct.
And before we talked about any deal, did you in fact give another sworn statement?
I did.
And that was prior to any deal being made. Is that accurate?
Correct.
Judge, at this time, the state is going to move into evidence what has been marked as P as in Papa.
Objection.
Well,
We already did three.
It's already been marked.
wait. P has been admitted into evidence.
Oh, because then it's O.
So then we need to.
Okay. Let's go down and grab the woman.
Your Honor, maybe sidebar again.
Well, in a minute. Right now, I'm going to set the stage or let the state set the stage for whatever they're doing, and then we'll...
Okay. There you go.
So where's the, you want this one in evidence now?
Yes,
Is
sir.
that an objection or?
Well, do we have an exhibit that's marked?
Yes, Judge.
What
It's
is
marked
the-
O as in Oscar.
Okay, and what are you doing with it?
Seeking to move it into evidence.
Okay, is there an objection?
Yes, sir.
Okay, so now we'll approach the bench. Conference won't accommodate. Okay, the jurors are gone. So first of all, I don't know what O is. I mean, you ask the witness if he remembers back in, I think, April of 2022, making another statement, and
That's right.
moved O into evidence.
Yes, sir. So, Judge, I'll let me explain. In April of 22, when we approached the defendant about potentially doing a deal with him, we said before we talk about anything, we want a sworn statement. And he gave us a sworn statement. Normally, that statement would not be admissible. It would be hearsay. However, under Rule 90.801...
No, wait a minute. So O is some...
O is that proffer that he gave, an audio of the proffer or the sworn statement that he gave to my office.
So you're moving it into evidence on Europe. Mr. Tucker's objecting, so let's hear what the state's basis of admissibility is.
90.801, subsection 2, subsection B. A statement is not hearsay if the declarant, Mr. Travis, testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. This defendant has been attacking this witness now for a day and a half about, you'd do anything to get out, wouldn't you? You'd say anything. You even said in the video, I'll do anything you want. He has made allegations of a fabrication on this defendant in order to get a deal. He's made allegations of improper influence of Penny Phelps. And he's made allegations of the motive to do it, meaning this defendant did not want to go to prison for life. So basically, he's here saying anything he has to say in order to avoid that. That's specifically what this rule is meant to address. So normally, a prior consistent statement would not be admissible, but now that that has been established, it is my position that statement should be admissible as a prior consistent statement offered to, I guess, to rebut allegations of improper influence, motive, or recent fabrication.
And the defense's position is?
The defense's position is that, again, as far as his motives, as far as the deal he cut, yeah, that one is self-explanatory. I didn't have to point that out. As far as Ms. Phelps, is she going to be addressed in that statement? The statement that you're trying to enter into evidence on cross? I mean, not a cross, I'm sorry, on redirect. You're trying to introduce new evidence into redirect, and does that actually establish, does it say anything about Penny Phelps?
I don't know.
Because, I mean, that's what he's using to establish this law here. He's trying to say that, you know, because we question Mrs. Phelps's motives, that would establish this law.
It's not a question of Phelps's motives, it's a question of this this witness's motives. He has been alleged to have fabricated this story in order to get a deal. He is alleged to have been improperly influenced in order to provide this story. This is specifically what this rule is designed for. It is specifically designed for a witness such as this who has been attacked by his motive for testifying, the content of his testimony being improperly influenced, and that it was fabricated to get a deal.
But does it allow you to enter new evidence on redirect?
Well, no,
Judge, I'm not teaching law to the defendant, so.
We're having a legal argument. This is exactly what when this whole business about the defendant wanting to play the interview, interrogation, whatever you want to call it, of Johnson with Penny Phelps, this is what I don't want to say warned about, but acknowledged that the door may be opened.
Yes, sir, that is correct.
I understand, Your Honor.
Excuse me?
I said I understand, Your Honor.
Okay, so now the question is this within that rule? So what's the rule?
Judge, it's 90.801, parentheses 2, subsection B.
What subsection?
I'm sorry, Judge, subsection 2B.
Table 4, right?
90.801.
Okay. The statement is not hearsay if the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement. And the statement is, subsection B, consistent with the declarant's testimony. It is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. I don't think this is recent fabrication, because recent fabrication would mean that somehow or other he's being alleged to have, in the very close to his testimony, fabricated, and then the advocate for that witness says, no, here's something that he said months ago that shows that this isn't recent fabrication. So it seems to me it's improper influence, that the Penny Phelps interview was played by the defendant to say that Penny Phelps fed you this narrative, to use the term that's been employed here, and you basically said, yeah, that's it, and it was her idea, not his idea. So, just the timing that I'm wondering about here. So the timing was the Phelps interview was in, when did we say? In
2017, Judge.
The testimony here is in 2024, and the statement that you want to admit is in 2022. So Could you just explain the argument again, Mr. Mansfield?
Right, Judge. So now that he has attacked the veracity of his statement as having been coerced by Penny Phelps, well, he gave another statement almost 5 years later, and it's consistent with the testimony he gave this jury on direct examination. So, again, if it was the Penny Phelps story, well, 5 years later, he gave a consistent version of those facts, identical to what he testified to this jury today. I'm sorry, during this trial.
Okay, and so anything further from the defense?
Well, I believe you already admitted there's inconsistencies between the interview he gave with Penny Phelps and what he's given today. Why would that be any different in that statement?
Not the inconsistencies. I believe the whole implication that the defense is wanting to say is it's basically the whole thing is a lie. That it's Penny Phelps' version of events that Johnson has just adopted as his own in so many words, and he's fine-tuned it a bit.
Yes.
But
Your Honor,
Yes,
if
sir.
I may, the statements that he made, again, Penny Phelps' time, yes, we do believe that they were fed to him. However, he's had 6 years now to fine-tune those statements.
Right.
So, again, even all the, yes, he was there. He can draw a map. Yes, he's there. He could do all that. He could do everything that the state's saying. That's true because he was there. That's very simple. And yes, because he was there, he can give all that information and probably keep it accurate. The part that's problem is that Penny Phelps gives him the one key that he needed to get that deal. I'm the getaway driver.
Judge, he keeps arguing the very nature of why he keeps arguing that Penny Phelps unduly influenced this defendant. And the rule allows for me to play a prior consistent statement that corroborates his version because the defendant has attacked it as being unduly influenced.
Your Honor, if I may, one other thing.
yes, sir.
Okay, this prior inconsistent statement, I mean, that would make sense if he had actually given that consistent statement prior to Penny Phelps. I'm sorry, prior consistent statement prior to Penny Phelps. Then it would make sense.
Judge Jones?
Yes.
In the abundance of caution, because I don't want to create an appellate issue, I'm not going to move it in. I'm not going to seek to move it in.
I think that's a wise choice. It's because one way or the other, it's a close call. I mean, one way or the other, it's a close call.
I truly believe this is the kind of trial that you get one shot at, so I don't want to create that issue.
Fine. May I ask, do you have a witness standing by?
Yes, sir, we do. Two of them.
I'd like to do recross, Your Honor.
Well, I don't think that's going to happen, Mr. Tucker. You've had more than ample opportunity to cross-examine about everything multiple times, so we're not going to be having any recross, sir.
Okay.
That's not the norm to begin with. I made an exception, but anyway, I won't repeat myself.
Judge, I just have a brief follow-up, and I'm done with this witness, and we'll move on to, I don't even know what time it is.
All right, bring in the jury, please.
Mr. Mansfield, who did the time call? Mr. Mansfield.
I'm sorry?
Was it the Emmy or the Angela?
Whoever's sitting out there, one of the
One of the two.
Okay, the clerk is concerned if there's some exhibit that's in the machine that she doesn't have. She's very mindful of keeping track of everything, which is definitely desirable. Thank you. Please be seated, everyone. Thank you for your patience. We've handled our business and back to the redirect of the defendant.
Thank you,
the
Judge.
witness, excuse me.
I'm sorry, sir. So picking back up, Mr. Johnson, so just to confirm, when you were approached in April of 22 about working with the state, you gave another sworn statement,
Correct.
and then you testified to the jury today.
Correct.
Were you consistent with that statement?
Yes.
Just 1 second, Judge. Judge, at this time, I have no further questions for this witness. Thank you, sir.
1 second. We're going to need to approach the bench here. Testimony now. You are subject to recall. So my suggestion is that you maintain some contact with the state to get further details.
Understood, Judge.
Any other instructions anybody wants at this point?
No, no, sir. I just would, since he's still under potential recall, no talking about the case to anybody outside the courtroom.
Correct.
Okay, take care. All right, so the state's next witness.
Yes, sir. We're going to call Dr. Michael Steckbauer.
Okay, I didn't know. I forgot. So you... Yeah.
Sir, if you please step forward through the gate right there. Approach the deputy who's positioned right in front of the witness stand. You stop about right there, turn, face this lady, raise your right hand.
Do you solemnly swear or affirm that the testimony you will give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Okay, thank you. Have a seat on the witness stand, please. Good afternoon, sir.
Afternoon. Judge, may I proceed?
Yes.
Dr. Steckbauer, you all set up? Okay.
I am.
All right, good. Good afternoon, sir.
Good afternoon.
Dr. Steckbauer, could you state your name for the jury?
Absolutely. I am Dr. Michael Robert Steckbauer.
And how are you employed?
I am the current District 16 medical examiner.
Did I mispronounce your name just now? Okay, good. Dr. Steckbauer, you are employed as our medical examiner?
I am.
And how long have you been doing that work down here in Monroe County?
About 6.5 years.
Okay. This is the part where I ask you to take the jury back a little bit about the progression of your career to get you to where you're at today.
Yes.
Yes, sir.
So that long odyssey started many years back. I went to undergraduate. Well, actually, that's not really true. Initially, out of high school, I went into the military. Did an active duty stint in the Army for 6 years as a veterinary technician, of all things. Thought I wanted to go to veterinary school. Clearly wanted to go to medical school. So then I went off to the University of Nevada, Las Vegas, and finished my bachelor's. I got a bachelor's in science with a minor in chemistry. Biology is the major, and minor was chemistry. I then went on to the University of Nevada School of Medicine to medical school, and I completed my medical degree. After that, I went off to my residency, which was in pathology, anatomic and clinical pathology. After completing that program at Ball Memorial Hospital in Muncie, Indiana, I did take what is called my anatomic pathology boards. This is essentially a test that one can take. You don't have to take it to practice, but if you take it, it shows that you have achieved a certain level of knowledge. So I did achieve board certification in anatomic pathology. I then attended my forensic pathology fellowship at the Miami-Dade Medical Examiner's Office. Upon completing that fellowship, I did also take my forensic boards and achieved board certification in forensic pathology. That entire time I was in the Army National Guard as well. I was a combat medic initially, and then later upon completion of medical school, I went to the Army's Flight Surgeons course and have been practicing with the Army National Guard as a flight surgeon since. When I graduated that fellowship, I went off to Duval County, Jacksonville, as an associate medical examiner. I was there for about 2 years, and during which time I was deployed to Kosovo with the Army National Guard. I then went down to Broward County as an associate medical examiner in 2013. Was there for a number of years, ultimately becoming their director of medical education at one point, later becoming their deputy chief, and at the end of that being deployed to Kuwait and Iraq with the Army National Guard. After that, I then came down here and have been in this position since. During this time here, I also have a private practice. I do the forensic autopsies for the Royal Police in the Turks and Caicos Islands, almost all of their cases. I do the hardcore forensic cases for the Royal Police in Bermuda, as well as in the Cayman Islands, and do private autopsies. I think that covers everything.
Okay. So you mentioned the phrase forensic pathologist, right?
Yes, yes, sir.
All right, let's tell the jury, what are the duties of a forensic pathologist?
Forensic pathology differs from general autopsy medicine, autopsy pathology, in that it specifically centers on medical legal death investigation. And really kind of to just be generally broad with that, it means we do autopsies that are legally mandated on things that would meet the classifications of manners of death of homicide, suicide, accident, so strange we just don't know what it is, undetermined. Now we do plenty of natural deaths as well in that work, but they're simply because there's no regular doctor to sign, or they don't know exactly what's going on, and so they're kind of questionable and they come to us. And so we do the background investigation into those cases. They come into the office. We do the autopsies on them, interpretation, follow-up interpretation of toxicology test results, and microscopic examination. Of course, we testify on those cases, such as I'm doing here today. We do education for law enforcement and fire, as well as a number of other people. We occasionally have medical students, residents, paramedic students rotating through the office. We do education with them. Occasionally we do outreach to different organizations, do training as well.
Doctor, you talked about autopsies. About how many autopsies have you performed in your career?
Well, I quit counting a number of years back. I'm probably roughly about 5,000 at the current moment.
And how many down here in Monroe County? Can you even estimate, or is it? Is that a rough one
Well,
to get
we
to?
do about 150 a year here in this county, 6.5 years, so you can do the math on that. It's roughly about 900. But of course, as I said, during that time, I have continued to do the cases for the Royal Police in those different island nations. You add those on top of it, it's probably somewhere around roundabouts another 100 cases, including my private autopsies per year. And then I did, in fact, help out the chief medical examiner in Palm Beach for a number of years. I'm not really sure how many I did total for her, but if we say somewhere between an estimate of 250 to 300 per year.
Wow. Now, are you a member of any specific groups or specialized groups?
Yeah, most pathologists, and specifically forensic pathologists in the United States, will be members of the National Association of Medical Examiners. It's really our only major group. We do have another group, but they're very minor compared to NAME for membership. Almost all forensic pathologists in the state are members of NAME. And then I am a fellow of the American Society of Clinical Pathology as well.
Have you ever been published?
I have.
And when I say published, what are we talking about?
Most of the time when you're talking about published, you're talking about either case reviews or full clinical research.
And you have been published before?
Yes, absolutely.
Do you receive continuing education in your field, or is it you've already known it, so that's it?
No, there are no current residencies under the guidance of the American College of Graduate Medical Education that are allowed to not do continuing medical education. You have to. So I do continuing medical education. I do that both for my board certification as well as for my medical licensure. The state licensure board here in Florida requires 30 to 40 credits of CME per year. Some certain classes mandated, others you can do it in whatever area of medicine you'd like. And then the American Board of Pathology requires 70 credits themselves.
And do you have to do that to maintain your accreditation or your certificate to practice?
My certification. Now, there is, I guess, one other caveat to that. I was unluckily one of the last people in my year group period that still had to take a high stakes test at 10 years to renew my board certification. Thankfully, they got rid of that and they changed it in pattern, but I did actually about a year, and I think that was a year and a half ago, I took a large exam, 10-year exam within my field to show, in fact, that I did still know what I knew and that I had kept up on it.
Now, are you board certified by the American Board of Pathology?
Yes, that is correct.
Is that above and beyond your regular certification, or is that the one we're talking about?
That is the one we're talking about.
All right, fair enough. Now, let's talk, you already explained to the jury an autopsy. You said an autopsy can determine cause and manner of death. Is that right?
Yes, that is correct.
So let's talk about the difference. When you say cause of death, what are you referring to?
The cause of death is that thing that led to the physiologic derangement in the body that was no longer compatible with life. The manner of death is a category that the cause of death fall within. I like to use the example of things like a firearm death. You can have a firearm death that is in fact homicidal. Somebody pulled the trigger and caused that person's death. You can have a firearm death that is suicidal. Somebody pulled the trigger themselves. You can have a firearm death, although they're not common, you can have a firearm death that is going to be accidental. The firing pin or something is malfunctioning and the weapon gets jostled, goes off, and the projectile strikes somebody. In that case, that's an accidental death.
Now, during the autopsy, you do something called an external examination and an internal examination. Is that fair?
That is correct.
Let's talk about the differences. First, external examination. What, if anything, are you looking for when you conduct that?
An external examination is exactly what it sounds like. It examines the external surface of the body. Now, I do tell everyone, especially when I have police from the Academy for the initial training, I say that the autopsy begins with the scene investigation. Whether that's a scene investigation that I directly perform or a scene investigation that the law enforcement officers have performed and relayed to me. You know, you can have a person who dies And without that information, you're kind of flying blind. You have a 30-year-old, who's dead in their bed. That could be potential drug overdose, could be suicidal, homicidal. And that investigation that they're performing is helping you to kind of move along the pathway of what may have caused it and what sort of ancillary testing you're going to do. So then we get the body into the morgue. We do the intake, which is weighing the body, doing some photographs, and we examine the outside of the body. The general hair, state of the hair, color of the hair, length of the hair, if there's any findings in any of these things. The eyes, the general color of the eyes, if there's any findings in the eyes that would help to indicate to you what the cause of death was. Is there some yellowing? They could have hepatitis, things like this. The mouth, are there any findings in the mouth? 30-year-old who comes to you and has no other findings, and the teeth are in very bad repair, you're immediately going to be concerned about things like methamphetamine addiction. So the teeth can actually steer you in certain directions as well. You can find little linear lacerations that indicate a person was punched in the lips, pressed against the teeth. You're then going to look at the outside of the body. Any marks, scars, identifying features, any tattoos, any injuries. Look at the genitalia. Are they normal? Are there any findings in the genitalia? And that roughly covers the external exam. Once you've finished the external exam and you've taken photography and documented it, you're going to move on to the internal examination of the body. Internal examination is exactly what it sounds like. You are going to open up the thoracic cavity and the abdomen via what is called a Y incision. The tissues will be reflected back. We document all of this in place. If photographs need to be taken, we do take them of any pertinent findings. We examine the organs in situ, inside the body as they present themselves, and then we remove them. We weigh them and we dissect them further. We take toxicology specimens as we go. If available, we try to get vitreous fluid from the eyes. We try to get peripheral blood, meaning blood that is away from the heart, towards the common iliac vessels. We gather urine if it's available. We gather bile from the gallbladder because certain substances are in fact concentrated in bile. Once we've done all of that, we then reflect the scalp, open the calvarium, of course examine the brain in place, take it out, weigh it, dissect it as well. We do keep small sections of, representative sections of all of these organs and any specific pertinent findings as we go. And again, like I said, we take photographs as we move along this process if they are needed.
Now, Dr. Sidebar, let's take you back to November of 2017. Were you conducting autopsies in Monroe County at that time?
I was.
All right. And were you asked to perform an autopsy on someone who came identified to you as Matthew Bonnet?
I was, and I did.
All right. And did you go to the scene on this particular death?
No, I did not.
Okay, sometimes you do go to the scene, right?
Absolutely.
All right, this one you didn't.
No, generally if the body has been transported from the scene, of course, I'm a forensic pathologist, not a crime scene investigator. My expertise is in that body. And so generally if the body has been transported to the hospital or otherwise, we do not attend the scene. And that was the case in this situation.
Okay. Now the identification of the body was Matthew Bonnet, is that right?
That is correct.
And you were asked to conduct an autopsy on Mr. Bonnet?
I was.
And do you recall when you conducted that autopsy?
Yes, the autopsy was conducted on the 21st of November at 10 a.m.
Is that at your office here in Monroe County?
Yes.
And were you alone or were you with someone when you conducted the autopsy?
Generally speaking, we almost always have a technician, and I would have had a technician on this case. I do believe at the time of this autopsy, Dr. Prasanna was present. There were a number of law enforcement officers who were present as well.
And okay, so you were asked to do the autopsy and you performed it, you said on the 21st, right?
That is correct.
Okay, so let's take the jury through the autopsy. First of all, can you describe Mr. Bonnet in general?
Absolutely. As per the report, the body is that of a 69-inch 173-pound adult white male who appears consistent with the reported age of 59 years. The body was well preserved. It was cold. Rigor mortis was present. Livor mortis was present. It was posterior, red, purple, and fixed. His hair was of medium length and white in color. The eyes were brown. The surrounding sclera were not icteric. The conjunctiva were not congested and did not have any petechiae. His nasal bridge was midline. The oral mucosa and frenula were intact, means he didn't have any defects within the mouth. The teeth are natural and in relatively good condition, and the external canals were free of blood. His neck was generally straight. His chest and back were symmetric outside of the injuries and medical intervention that were present. His abdomen was flat. His external genitalia were those of a normal circumcised adult male. The testes were palpable in the scrotum. His external anus was unremarkable. His arms and legs were normally developed. He did, in fact, arrive to my office with bags covering the hands. That is normal to do in cases in which it is believed that an altercation has occurred. It allows us to better process the hands and potentially take things like fingernail clippings, because DNA can be present underneath the fingernails from the person that they may have gotten in an altercation with. And so bags were present on his hands. They were removed by me, and I did, in fact, obtain fingernail clippings from Mr. Bonnet. There was a scar, a 3-inch hypopigmented linear scar in the lower midline of his abdomen. He did also have what we call our senile ecchymoses that had minor superficial skin lacerations. These are kind of what people call old age bruises.
Anything on the external, any evidence of fatal injury on the external examination?
Yes, absolutely.
And what, is there anything to do with it?
So moving on to the evidence of injury section on the report, initially the first thing that we described was a stab wound of his left upper arm. And the report has some specific measurements, and it has measurements of the actual wound. It has some measurements that kind of orient it on the body, and how, whether or not it has 2 sharp edges or just one. In this case, it had a single sharp edge at 9 o'clock. This helps us. It helps to indicate whether or not we have a single-edged weapon or potentially a weapon that has a serrated edge on the opposing side. And then it was described as having only gone down into the muscle and soft tissue about 2 inches. He also had another stab wound of his left upper arm.
You said that was in the upper arm, is that right?
That is correct. Left upper arm.
Left upper arm?
Yes.
Front, back, or side?
Specifically, that wound is 11.5 inches from the top of the head and 8 inches left of the midline. And so it is in the lateral aspect of that arm.
And would that wound have been fatal?
No, it would not.
And from the, I guess from the cut that was made on the body, I guess when inflicting that wound, can you give us any information on the knife that potentially was used based on that wound?
Well, again, as I stated a moment ago, it had a sharp edge that was at the 9 o'clock margin of the wound. And so that is indicative of a weapon that is not double-edged. Now, it doesn't mean that the weapon can't have a side that is serrated, but it does indicate that it is unlikely that it is a double-edged knife.
And that's for, as far as that wound, correct?
That is correct.
Okay. Now, there are other wounds, is that fair to say?
Absolutely. There was another stab wound within the left upper arm. It is also to the relative lateral, the outside aspect of the arm. It was T-shaped. It's a 4.3 by 1.5 centimeter stab wound. It was 14 inches from the top of the head and 11.5 inches left of the midline. That stab wound went down about 3 3/4 inches into the muscle and soft tissue of the left upper arm. So that's a decent distance. You think about that, 3 3/4 inches is right about there.
And again, that's in the upper left arm, near the other wound?
Near, yes.
Okay, and that was in the arm. Would that would have been fatal?
No.
Okay, let's go on to the next one.
The next wound is a stab wound of the mid-back. This wound specifically is a 3.2 by 0.5 centimeter stab wound. It is 18.5 inches from the top of the head and 1 inch left of the midline. And again, it is in the left side of the mid-back. It's oriented from 9 o'clock to 3 o'clock and reapproximates to 3.3 centimeters. These are just things we use when we describe the wounds. The path of the wound extends down into the posterior aspect, the back of the left side of the chest at the 10th and 11th ribs. It then goes into the thoracic cavity and it goes through the left side of the diaphragm. It does not injure any other major structures. There is a liter of liquid and clotted blood that's collected within the abdominal cavity that is associated with that wound. That wound specifically has a directionality that is from left to right, front to back, and downwards.
And that was, you said that was the first wound in the mid-back, is that right?
That is correct.
All right. And would that wound have been potentially fatal?
It could have been fatal if, in fact, no care was rendered. It did not injure any large major structures, but by going into the back and going through the diaphragm, it absolutely would have caused a pneumothorax, and no medical attention would have meant that he would have passed away.
Now, let's go on to the next. Was there another wound in the back as well?
Absolutely. There are two combined wounds in the mid-back, and they are described exactly as that, two stab wounds in the mid-back that form a general L shape. And the first is given some description, same as these other wounds that we talked about, the measurements of it, 3.5 by 0.6 centimeter stab wound that is 14.5 inches from the top of the head and 2 1/4 inches left of the midline. In the left side of the mid-back, it's oriented from 7 o'clock to 1 o'clock and reapproximates to 3.7 centimeters. The second wound that connects with this, making that L shape, is 2.8 by 0.5 centimeters. It's 15 inches from the top of the head and 2.5 inches left of the midline in the mid-back. It's oriented from 9 o'clock to 3:30 and reapproximates to 2.8 centimeters. So then in the report, what I did with this, because these wounds do what we call commingle, they combine, I described it as such. I said, please note that due to commingling of the wound tracks of these two stab wounds, they are described together. The path of the wound extends down. It enters the posterior aspect, the back of the left side of the thoracic cavity, the chest, at the 7th and 8th intercostal space. The wound tract, the injures the descending aorta at the level of the 9th thoracic vertebra, and the left lower lung lobe is also perforated. Associated with that wound is a liter of liquid and clotted blood in the left side of the thoracic cavity. And the path of that wound is from back to front, left to right, and downwards.
Now, you did say you photographed during the autopsy, is that correct?
I did.
All right. Judge, have you already shown defense counsel was marked as Quebec composite, 4 photos in it? May I approach the witness?
Yes.
Can you take a look at those 4 photos and tell me if you recognize them?
So far, yes. Let me look at the rest. Yes, I do recognize them.
Okay, and are those photographs consistent with the person that you performed the autopsy on?
Yes.
And some of them are actually from the autopsy, is that accurate?
Yes, all but one are from the actual autopsy.
Judge, at this time, I seek to move into Quebec.
Any objection?
No, Your Honor.
All right, state's exhibit Q for identification is now admitted into evidence is number 16. That's a composite exhibit. A through D.
right, Dr. Sidebar, so now that it's in evidence as state 16, composite, judged by a published to the jury.
Yes.
First, I'm going to show the jury the first photo, and that's Dr. Sidebar, and what do they see here?
This is a photo that law enforcement frequently sends us. We ask for something for an identifying image of the decedent when they first call us. If they have a driver's license, they send us a driver's license. If not, they will send us a copy of their screen, the computer screen. We always call it a David photo.
So does this help you in the identification process?
It does. It helps them in the identification process.
Now, let's talk about the wounds that you just testified to. I'm going to show them this one next, Dr. Sidebar, just so you understand. And then if you could just tell the jury what they're going to see in this photograph, or these two photographs.
So what you're seeing in these two photographs is you're seeing one of our standard photographs of the lower half of the back of the decedent. But you're also seeing one of our other standard photographs of the upper half of the back of the decedent. And in that upper half, you can see that there are two injuries of the back. You don't see them as well because this is a general overall photo. Those photos are taken much closer as well.
Does the picture of the back kind of elucidate where those where those stab wounds were that you were testifying to?
It does.
And the one looks almost like a V or something. Is that the one that you talked about having combined?
Yes,
A combination of two stab wounds?
absolutely.
So, and then there's another one down here. Is that right?
Correct.
All right, so let's talk about this one here. This is going to be D in the composite,
Yes.
okay? If you want to narrate it while I show the jury.
Sure. So this is exactly what I was talking about. We did, in fact, do a close-up photo of those injuries with what is called an L ruler. It's a legal ruler. But there's also another photo there. This is as the tissue has been reflected away. That photo is actually of the injury from one of the stab wounds of the arm. It's showing that it goes into the deltoid muscle.
That's this one over here.
Yes, that is correct.
So one's a real up close and personal look at the arm injury, and the other one is a closer look on the two back stabs.
Correct.
Am I saying that accurately?
Yes.
All right, and then we got one more. Dr. Sidebar, were you ever provided with a weapon in this case to examine?
I was.
Here's what the jury's going to see in this one.
So these
And I'm sorry, this is for the record, this is 16B.
These photographs, the top one is actually just a standard image we take. It is what we call a face shot. These are often used for identification by family members and others because they can be cleaned up on a computer surface. The bottom one is a picture of the knife that was presented to us at autopsy as potentially being the weapon that was used.
And what was the purpose of presenting you with the knife?
The primary reason that they presented me with the knife is that there is a laceration, abrasion, impression along the nose that is quite consistent with the butt of that knife. They wanted to compare those two. We do, in fact, have an autopsy photograph where that knife is held adjacent to the decedent's nose, comparing the back of that knife to the impression along his nose.
Were you able to opine at all whether that knife would be consistent with the stab wounds that you discovered on Mr. Bonnet?
Yes, it is.
It is consistent.
It is.
Okay, and can you give the jury, like, how do you go about that examination of the knife to the wounds?
Whenever you're professionally trying to evaluate and say, could this be consistent with or not, you're looking at things like what we talked about earlier. Is the wound single-edged? Is it double-edged? Is the weapon single-edged? Is it double-edged? Things like this. If we have injuries that could have been caused by another part of the weapon, are there patterns to those injuries that would go along with some part of that weapon? In this case, of course, we do. And so when you evaluate those things together, it makes the instrument, the weapon, consistent with the injuries that you're seeing.
Dr. Sidebar, I'm going to show you what's in evidence now. It states 14. And have you take a look. Oops. Do you recognize it?
Yes, it is the knife that was presented to me at the autopsy.
All right, and take a look at the blade of the knife. Is it that two different sides, or is it all consistent?
It does, in fact, have two different sides. One has a normal sharp edge, and the other has what we call a serrated edge.
Now, the stab wounds in the back, is it consistent? Are those injuries consistent with having been caused by this knife?
Yes.
And what about the ones in the arm?
Yes.
And then you said the blood of the knife also caused a nose injury?
It is consistent with the injury on the nose.
Okay. Can I have that perfect picture? One or two. Dr. Sidebar, I'm going to show you what's already in evidence in state 6. You recognize the photo?
I do.
Is that Mr. Bonnet?
It is.
Now you see a nose injury there, right?
Yes.
Is that the nose injury you're talking about?
It is.
And you said it's consistent with having been caused by the butt of the knife?
It is. This photograph does not depict the pattern well. There is another photograph that depicts it much better.
Did you do a thank you, ladies. Did you do a toxicology on this person?
Yes, we did.
And when I say a toxicology, what exactly am I talking about?
It means that we did, in fact, obtain the specimens that we spoke about earlier. We did, in fact, obtain blood from the iliac vessel. We did obtain urine, bile, and vitreous fluid, and we did send those off to the University of Florida Toxicology Lab in Gainesville for testing.
And did you receive those results?
We did.
And what, if anything, did that test reveal as far as what was in Mr. Bonnet's system?
So the test revealed that his blood was in fact positive for ethanol, alcohol, at 140 milligrams per deciliter or 0.14 grams per deciliter. And they do that conversion because it helps people to understand it. When you say 0.14, you can compare that to your reference range of 0.08 being the legal limit for driving while intoxicated. And so it kind of gives you just a general reference, and that's why they do that. The blood was also positive for cocaine at 301 nanograms per milliliter. This is important because cocaine is one of the fastest metabolizing drugs in humans. Almost all parent cocaine will have been metabolized to its metabolites within about 15 to 25 minutes. So having parent cocaine is significant in that it means that that cocaine would usually have been taken within the last 15 to 25 minutes. Otherwise, we would only have metabolite. We also have coca-ethylene, which was positive at 421 nanograms per milliliter. This is important because it lets you know that there has been some metabolism time between the alcohol and the cocaine. Those two combine together and create the metabolite coca-ethylene. Benzoylecgonine was also positive in the blood. That is the primary metabolite, active metabolite of cocaine. It was present at a level of 1,958 nanograms per milliliter. And then when we look at...
Hold on, let me ask you a quick follow-up question. On the cocaine, were you able to, by the levels of these various breakdowns, I'm not going to try to pronounce them, but are you able to tell how recently he had used cocaine prior to his stabbing?
Right. So just to correct myself, it's 1,968 grams. Should have used my glasses, clearly. Just want to make sure I said not 1,958, it's 68. And yes, as I was describing earlier, we can say that at least the cocaine itself was used within roughly 15 to 25 minutes of his death because, again, we had parent cocaine in the blood.
And that's indicative from the coca-ethylene?
From the cocaine itself, because
from
again,
the cocaine itself.
Cocaine metabolizes relatively quickly, and so if you have parent cocaine in the blood, that means that cocaine was ingested or used within the last 15 to 25 minutes. The metabolites could in fact be due to the ingestion or use of the cocaine that we're seeing that's still in the blood, or they could be metabolites that are partially due to prior use as well. I cannot say that.
So the parent cocaine, the fact that it's in the system, would give you that time estimate of the last 15 to 20 minutes because it metabolizes rather quickly.
Correct.
All right, let's go on to the presence of any cannabinoids.
Okay, so
I was going to offer you my glasses.
Yeah, might as well.
See that?
There are cannabinoids present in the urine as well. They're positive. It is important to understand that urine indicates past use. Urine does not indicate current use. Blood indicates current use. And there were no cannabinoids identified within the blood. They were only identified within the urine, which again means past use.
Past use not present at the time when he was stabbed.
Correct.
All right, so then anything else of evidentiary value from the toxicology report?
Well, there are, I mean, it just depends on the questions that would be asked. The urine was also positive for ethanol at 185 milligrams per deciliter, and the vitreous humor, the fluid from the eyes, was positive at 140 milligrams per deciliter. Now, it is important to oftentimes we look at blood versus vitreous fluid for different drug levels to say whether they're still in the absorptive phase or metabolic phase. In this case, they're equal. Both were 140, so that means that he's kind of at a steady state. Of
alcohol consumption.
Of alcohol, correct. And the urine was also positive for those other metabolites in active parent cocaine that we talked about, the cocaethylene and the benzoyl 9.
Now you had said, so in all, he had cocaine and alcohol in his system. Is that fair to say?
In their metabolites, correct.
And you had mentioned his hands had been bagged, right, for preservation?
Correct.
Did you submit fingernail clippings?
I did, in fact, turn them over to law enforcement.
Okay.
Law enforcement then submits those fingernail clippings.
Did you provide them to law enforcement for further testing?
I did.
And did you also provide a DNA card for Mr. Bonnet for further testing?
I did.
Now, Dr. Sidebar, when all was said and done, did you make any findings to a degree of medical certainty as to the cause of death here?
Yes, in this case, the cause of death was stated as multiple sharp force injuries and the manner of death as homicide.
Now, how are you able to determine it was multiple sharp force injuries and not cocaine overdose?
Well, again, the one injury, well, the two combined injuries that we spoke about.
The one that formed the V in the back?
Right. They, in fact, did injure the aorta, and they, in fact, did cause a good amount of blood to collect within the thoracic cavity. That is not compatible with life. It also had the injury that went through the diaphragm and up into the thoracic cavity and the blood within the abdomen. Those are not compatible with life. Although any amount of cocaine can cause a person's death, clearly the sharp force injuries were much more, I don't want to say impressive,
Dominant?
They would have a much greater effect.
So the fact that the stab wound in the back punctured or perforated the aorta, is that a fairly significant wound?
Yes, the aorta is the largest blood vessel in the body. It's under high pressure, which is why that blood collects within those cavities. The blood that would have been lost is, of course, probably even greater than that which we quantitated, because blood is going to have come out of those wounds. On top of that, you had emergency personnel who, in fact, were trying to save his life. They did a thoracotomy procedure in which they did open the chest in a way that we call a clamshell, which literally means they make a large incision, they open it up. They're trying to get access to repair those injuries emergently so that they can stabilize the person. And so some of the blood would have been lost then as well. So it's almost a certainty that he had lost more blood than what we're talking about in the report.
Now, did you issue a death certificate in Matthew Bonnet's name in this case?
I did.
And on the death certificate, you put in the information about cause and manner of death?
I did.
Was there, Dr. Steckbar, I'm curious, was there any evidence on his body, Mr. Bonnet's body, of a struggle? Was there bruising on his arms or legs or knuckles, anything that would be evidence consistent with a struggle?
Well, he does have some additional injuries, and depending on how you would categorize those injuries, some of them could be indicative of a struggle. He had some bruising of the knees, if I remember correctly. For some reason. Oh, that's why. So specifically, he had a laceration. It was surrounding purple bruising of the bridge of the nose. We talked about that. He had a red abrasion, linear red abrasion of the bridge of the nose. He had an abrasion of the right cheek. He did have a healing wound of the right knee. Now, that's not indicative of an altercation at the current time because, of course, it's healing. But he did, in fact, have a purple-brown bruise of the right knee, which could be indicative of an altercation. He also had a brown bruise in the right foot, which could have been part of this altercation. He had a healing wound of the left knee. Again, it's healing, so it's old. He had a red abrasion of the left side of the upper aspect of the chest, which could have been a part of this altercation. He did also have a superficial red abrasion of the left upper extremity. Again, could have been a part of this altercation. And he had a laceration in the left upper extremity, which could have been a part of this altercation.
So many of those would be consistent with some kind of a struggle or a fight at the time of his stabbing.
Yes.
Judge, if I just may have 1 second.
Yes.
Judge, at this time, I have nothing further for Dr. Steckbar. Sir, thank you for your time today.
Right. We're going to take a little break before we have cross-examination. We've been in session here for a couple hours, so bear with us. It's going to be a 15-minute break. Members of the jury, you don't have to stay in the jury room. It's follow the usual procedures. 3:21, that would put us to 3:36. So see you back here. Continue the testimony. All right, our jurors have exited the courtroom. You can take a break also, Doctor. Just remember, we have the rule of sequestration of witnesses, so you're not to discuss your testimony with anyone during the break. Any other instructions? No? All right, we'll be back. Excuse me? I see him. You'd please come on back up to the witness stand, Doctor. Okay, welcome back. The jurors brought in. Still under oath. Good.
No, thank you for asking.
Everybody's here who should be. Bring in the jury, please. Thank you. Please be seated, everyone. Welcome back to the courtroom, members of the jury. We have the witness back on the witness stand, remain under oath, so let's...
Judge, I'm done with the witness. Before I sat down, I wanted to move into evidence was previously marked as Romeo. It's a death certificate.
Is there any objection?
No.
All right. Admit number 17 for the state. All right. So now cross-examination.
Forgot to say good afternoon when I came in. I was such of a rush. Good, welcome back. Dr. Sackbauer, I'm going to make this real quick, real painless, I think. I would hope. Now, in your report, you stated that the knife is consistent with the wounds and it is most likely what killed Matthew Bonnet, correct?
Consistent with.
Consistent with it. Okay, so not exactly, it's not 100% sure, but it is consistent, correct?
Correct.
Okay, good. Same thing with the was it the injury on the bridge of the nose?
Yes, correct.
And now you said you do DNA spot cards. We did a depo with you, I believe, and I was reading something about your DNA spot cards. Could you please explain what that is?
Oh, absolutely. So we do in this office, we do a DNA spot card on all of the autopsies or even external examinations we do. We obtain blood from the decedent and we make what we call a spot card. These are just little cards. They have little circles. You've probably seen them on Hollywood. We do actually use professional spot cards, which means we purchased ones. The paper is impregnated with certain substances to help stabilize the DNA for testing, and then we make them and we retain them. The majority of those spot cards never actually get tested. They're just retained in the file.
Okay, so they're retained by the medical examiner's
By
office?
my office.
Okay.
Yes, sir.
Okay. And again, when I was reading our deposition of you, you were made aware of the DNA results. Is that correct?
To be honest, I don't recollect.
I would imagine not. It was quite a while ago. Now, without going into the DNA results, one of the other things I happened to notice in our deposition of you, if two different blood types, two different samples of blood are found on the same blade, what is that indicative of?
If two
different
blood
separate
types.
samples, yeah, two different.
Not two different DNA patterns, just two different blood types.
Yeah, two different. I guess even two different DNA patterns. If you find multiple sets of blood, I guess on the same blade, it would be the better way. I'm a layman, so you gotta excuse my lack of medical knowledge here. But if you found two different types of blood on the blade, what would that be indicative of?
It would indicate that there were two contributors.
Two contributors.
Two people.
Okay, and which would mean that blade was probably used on both people, correct?
It would just mean that substance containing two people's DNA was on the knife or whatever object was
Right.
tested. It wouldn't necessarily mean that it was used on two people because, of course, you cast DNA simply from your palm, but of course it could have been used on two people too. I don't know.
I think I understand what you're saying here.
I'm sorry, Mr. Toker. Would you mind moving the podium
Yes, I
here
sure
a little
can.
bit because
I sure
I'm
can.
having
I'm
a hard
sorry.
time seeing the state's table, and I do need to be able to see everyone. Thank you.
Thank you. Now, it wouldn't be 100% conclusive, is what you're trying to say, I think.
Well, I wouldn't say that. The fact that you would get a profile, and I would leave that to an expert in DNA to talk about the likelihood that a given DNA profile belongs to a given individual. Statistically, I would definitely leave that alone. But I wouldn't say that having a profile on a weapon means that that person had to be involved in using the weapon or not using the weapon. I wouldn't testify that. I would simply state that if I was made aware of it, that their profile was found on the weapon.
Okay.
I don't know if that
I
answers
think
the
you
question.
I think, again, layman here, I think you were talking about DNA transfer from other things too, it's a possibility or, that kind of thing.
Judge, I'm going to object the question.
Oh, yeah, let me try and rephrase. Like I said, I'm trying to key in on medical terms that I'm not exactly familiar with. Okay. Again, we're going back to the DNA or the blood of different people being found on the object, whatever the object would be. Would that be consistent with that object being, again, coming into contact with both of those people?
Yes, absolutely.
Okay, I think that's a better way. I should have said it. Now, again, that would mean it most likely would be contact, though, not secondary contact, like we were just like I was just trying to describe. Secondary, like, okay.
I definitely wouldn't testify. It's okay. I wouldn't testify to that.
Right.
The likelihood, I would definitely defer to an expert in
DNA.
DNA.
Okay,
Absolutely.
good. Okay, and but you didn't test the knife, correct?
I did not, no.
Okay. And again, I think let me check here, because I don't think there's too much else we need to go into. Now, just to clarify, when we were discussing all the wound patterns and the paths that you were talking about, now that doesn't say, again, it doesn't tell you much about the assailant, does it? The type of assailant.
No, not at all.
Okay, so it can't tell you how big, how tall, how, whether the right or left-handed, any of that.
No, it cannot.
Okay. So it doesn't tell you much about the assailant other than this is consistent, this weapon is consistent with the wounds.
Correct.
Okay. All right, and let's see. Oh, and I don't think you'll remember this. I don't know if you would remember, during the deposition, I don't know if you saw the other victim in the case, Miss Paula Belmont. They showed you laceration. They showed you a neck wound.
Well, I'll listen to the question, but
Let me try and get to a question that's a little bit quicker and easier here. Were you shown pictures of the victim, the other victim, Paula Belmont, when you were doing the
I don't
demo?
recollect.
I had a feeling a long time ago. Okay, and I'll tell you, there's not much else I think we need to go in with you, Doctor. Thank you for your time. I think we've addressed everything that we need to, so we can be excused.
all right.
I'm done with my cross.
All right, thank you. Is there any redirect?
Yes, Dr. Stepfauer, the knife that I showed you, the one with the red and black handle, the one that's in evidence.
Yes,
Is that consistent with having inflicted the wounds in Matthew Bonnet's back?
it is.
Now, that knife has a serrated side and a straight edge or a smooth side, right?
A sharp edge and a serrated edge. Yes.
Sharp edge on one side, serrated edge on the other. And is that reflected in the wounds that you see in his back?
Yes.
So I guess one side of that wound has a serrated pattern and the other side has a smooth cut?
Well, the real primary thing is that you have a single sharp edge. Serrated wounds, serrated weapons can make specific patterned wounds. These wounds did not have a specific pattern that is directly associated with the serrated edge, just with not having two sharp edges.
Okay, so ultimately though, that knife that is in evidence you said is consistent with having inflicted the wounds in Matthew Bonnet?
It is.
Okay. I don't have anything else for you, Dr. Stepfauer. Thank you, sir.
Thank
All
you.
right, then. Thank you, sir. You can step down and be excused.
Thank you, Your Honor.
You have all the exhibits here.
Thank you, sir.
State prepared to call their next witness.
Yes, Your Honor. State. We'll call Angela Ozlowski.
Maybe sidebar for just a second, Your Honor.
Excuse me?
Maybe sidebar for just a second.
Okay. please come forward, ma'am? Could you approach the deputy there? Stop. Face the clerk. Raise your right hand.
Do you solemnly swear or affirm that the testimony you will give in the cause now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Please have a seat on the witness stand. Speak loudly and clearly.
Permission to proceed, Your Honor.
Yes.
Good afternoon.
Good afternoon.
Please state your name and spell your last name for the record.
Angela Oslowski, Oslowski.
And where are you currently employed, ma'am?
With the Florida Department of Law Enforcement in the Fort Myers Regional Operations Center.
How long have you been still employed in that capacity?
Since January of 2016.
Okay, and what is your position with the Florida Department of Law Enforcement?
I'm a crime laboratory analyst in the biology section.
Okay, would you please be so kind to explain for the jury your educational background?
So I have a Bachelor's of Science in Biochemistry Forensic Science from Suffolk University in Boston, Massachusetts, and I have a Master's of Science in Forensic DNA and Serology from the University of Florida.
What are your duties as a crime laboratory analyst in the biology section of Florida Department of Law Enforcement?
So as a crime laboratory analyst in the biology section, I analyze items of evidence for the possible presence of biological material, collect samples for DNA analysis, interpret my results, write reports, and testify in court as needed.
What, if any, specialized training do you have for your position as a crime laboratory analyst?
So with the Florida Department of Law Enforcement, I underwent a two-part training program in which first I learned about the serological processes or the testing for biological material. I took written, oral, and practical examinations and then did supervised casework under a qualified analyst. And then the second part of my training was for the DNA analysis process. And I also did written, oral, and practical examinations and then the supervised casework under a qualified analyst for that portion as well.
Okay, and as a crime laboratory analyst for FDLE, do you have an occasion to perform DNA testing?
Yes, I do.
And approximately how many times have you performed DNA testing in your career as an analyst for FDLE?
I would say it's at least been over 5,000 samples.
Okay, over 5,000 samples?
Yes.
And how long have you been performing DNA testing?
So since November of 2017 when I completed my training.
In addition to your background training, do you undergo any proficiency testing?
Yes, I do.
Please explain to the jury what type of proficiency testing you undergo.
So twice a year, I will get samples from an outside laboratory in which they know what results are expected from the samples that I'll be working. I work them as if they're regular casework samples. I'll obtain results and report my results to them, and this will test my ability to do my job as well as the DNA analysis system.
Have you ever been qualified as an expert in DNA testing?
Yes, through the Florida Department of Law Enforcement.
And have you previously testified in court as an expert in DNA testing?
Yes, I have.
Approximately how many times?
Approximately 25 times.
Judge, at this time, I would ask the court to recognize Ms. Oslowski as an expert in the area of DNA testing and analysis.
Any objection?
No, Your Honor.
Recognize the witness in that area of expertise.
Thank you, Your Honor. Ms. Oslowski, please explain in layman's terms as best as you can, what is DNA?
So DNA stands for deoxyribonucleic acid. It's the basic building block of all human beings. You get half of your DNA from your mother and half of your DNA from your father, and it's essentially what gives you your height, eye color, hair color, things of that nature. Greater than 99% of your DNA will be the same among each person, and less than 1% is what varies among each person, other than identical twins, which will have the exact same DNA types.
Were you asked to perform DNA testing in this case?
Yes, I was.
Please explain for the jury what type of, or what method of DNA testing you utilized in this case.
So I test for something called short tandem repeats, which are actually short segments of DNA that each person has, but what varies is how often these short segments repeat. So for example, since I get one type from my mother and one type from my father, at one location I might have 11 repeats, and 12 repeats. And then another person might have 9 and 10. And I actually test 21 of these different locations.
Okay, and what method of DNA, I'm sorry, what are the steps used in short tandem repeat DNA analysis?
So there are 4 steps. So first, I will either collect a sample from an item of evidence or take a cutting from an item of evidence, and this will get heat and chemicals, and this helps break open the cells so I have access to the DNA within it, and it also helps clean up the sample. Next, the sample will go through something called quantitation, in which we'll see how much DNA is actually present already in the sample. Then the sample will go through something called amplification, in which those 21 short tandem repeat locations will be amplified millions of times. And this way, during capillary electrophoresis, which is essentially a part of the process that separates the DNA out by size, so that way I can then look at it on a graphical type of form so I can interpret the DNA results.
Thank you. And as an analyst, what procedures do you take to assure the quality of the testing?
So when looking at items of evidence, I ensure that I use a face mask, hairnet, lab coat, disposable gloves, and then every area and utensils are cleaned with something called cavicide that will remove DNA. And then during each step of the process, something called controls are used to ensure that each step of the process is working correctly.
Please explain for the members of the jury, what are controls?
So controls are there'll usually be a positive and a negative control. So a positive control will contain something that I'm expecting to get a result from, and it'll get the chemicals or whatever part of the process that I'm utilizing, and it'll get all of those elements. And I'll expect to get a result from that, and that shows that everything or all the reagents in that step of the process was working correctly. And then the negative control will still get all the reagents, but nothing else in it. So that way I would expect to just still get absolutely no results obtained for that, just to show that nothing extra was added in at any point.
Is the laboratory where you conduct your testing at, is it accredited?
Yes, it is.
Okay, from who?
From the American National Standards Institute of National Accreditation Board.
And for the jury's knowledge, what does that mean?
So that means that my laboratory is following a set of certain high standards that are set forth in the forensic and scientific community.
Once you finish your DNA analysis process, what types of results can you obtain from your procedures?
So after doing that 4-step process, I can get something called a single source profile, in which I have DNA at all 21 locations, where I would say it's a complete single source profile. So that indicates that I got information at all 21 of those locations, and it's indicative of one individual. I can also get a mixed DNA profile, in which I have DNA results that indicate there's more than one individual that's present. I can also get DNA results that are too limited to interpret, which means that I had some information that was obtained, but because of its limited nature, it's not enough to say how many individuals are present and to do any comparisons to. I can also get DNA results that are too complex, in which there are more than 4 donors present, and therefore I really truly can't say how many individuals are in the sample, and therefore I cannot interpret that as well. And then I can also sometimes get a mixed DNA profile, but there's one clear high donor, and the information for the additional contributor is very limited. And so I can call that profile, I'll say it's a major DNA profile that was obtained, and I can do comparisons to that high profile that's present.
Okay, and what are your results used for?
So the results from the evidence samples are used to then compare to standards or known samples of DNA collected from individuals.
Explain for the jury what are standards.
So a standard is usually collected as a buccal swab, which is a swab directly from an individual's inside cheek or buccal cells, or it can also be blood stain card or blood. And this is to represent, so it'll go through that 4-step of the DNA analysis process in order to get a DNA profile to represent that person's DNA.
Okay, and did you receive standards in this case?
Yes, I did.
Would you please explain or tell the jury what standards you utilized in this case?
Is it okay if I refer to my notes just for
yes,
the
it'll refresh your
names?
recollection, Your Honor.
So I obtained buccal swabs from Franklin Tucker, buccal swabs from Rory Wilson, excuse me, buccal swabs from John Johnson. I also obtained a blood stain card from a Matthew Bonnet, as well as buccal swabs from a Paula Belmonte. And then I believe I also got buccal swabs represented as being from a Roger Raggett.
And did you do the testing and compare those buccal swabs compared with other items of evidence that you were requested to do so in this case?
Yes, so for each of those samples, it went through that 4-step of the DNA analysis process, and I was able to get complete DNA results from all of those standards to represent individuals, and then comparisons were made to question samples in this case.
Okay, now, talking about the results, what are possible results as a result of your testing? Is there things that, for instance, explain to the jury what does inconclusive mean to you?
So inconclusive, so when I'm doing a comparison to a DNA profile from a questioned item of evidence, in which I have results that are comparable or interpretable, I then do a comparison to a standard, and sometimes when that comparison is done, the result is it's inconclusive. And this essentially means that I cannot say for certain if that individual is included or excluded as a possible contributor to the mixed DNA profile. So when I'm doing comparisons, I do something that's called a likelihood ratio, which is essentially comparing one event under two separate situations. So it's usually the DNA results given if a person contributed their DNA versus another person in the population with those DNA types. So when I'm doing that comparison, if it falls in that inconclusive zone, it'll be a range in which during my validation, it showed that there were some false inclusions and false exclusions when compared to standards. So in that range, I truly cannot say if that person is included as a possible contributor or excluded as a possible contributor.
Okay. Based on your training, experience, your expertise in the area, would there be instances where there is no DNA, or there is not sufficient DNA for you to come to a determination?
Yes. Sometimes with items of evidence, as I said, the DNA might just be too limited, so I can't do any comparisons to it, or other times even with a mixed DNA profile, there might be information for a contributor or one of the individuals that makes up that mixed DNA profile that is higher and easily comparable to, and then sometimes there might be a second or a third donor that's a little bit more limited in nature and has less DNA types present. And a lot of times that's where the inconclusive comparison will be seen.
For instance, is there necessary automatic DNA on this pen because I'm holding it in my hand?
Not all the time. So DNA, it depends on a lot of different factors that can contribute to DNA being left behind. So it depends on the individual. Some individuals shed their DNA more easily than other individuals. And then on the item, it depends on length of contact. So the longer one holds onto an item, the more likely I'm expecting to see DNA present. If someone touches an item very briefly, it's less likely to see that DNA present. Also, depending on the item, the DNA that's possibly already on that item, as well as the item itself. If it's a smooth item, less DNA usually gets left behind versus a rough item, because rough surfaces will kind of slough off more DNA. So it really depends on many factors.
Okay. If a person had gloves on, would that affect the DNA analysis?
Yes, that can affect leaving DNA behind.
And it would mean it would be less likely that DNA would be left or present on a particular item of evidence that you were asked to examine, correct?
Yes, that's possible.
Judge, may I have a moment?
Yes.
Mr. Zlowski, I think you said Mr. Tucker was one of the standards that you received in this case, correct?
Correct.
And there were inconclusive items that you could not include him in with respect to certain pieces of evidence. Is that fair to say?
Some of the items that I did do comparisons to his standard were inconclusive, and I could not say whether he was included or excluded as a possible contributor to those items.
Nothing further from this witness, Your Honor. Thank you.
Okay. Cross-examination?
Agent Oslowski, I don't know.
Just crime laboratory analyst Oslowski.
Okay, got it.
Or analyst
Good to know.
Oslowski is fine.
Did you get the subpoena that I tried to send?
I don't think so.
Okay, just checking. Maybe I had the wrong email, whatever. Okay, so we just heard the prosecutor go over the explanation for inconclusive results. Now, did you get some conclusive results in this case?
So there was some DNA evidence that I compared the buccal swabs, and he was excluded as a possible contributor to those DNA profiles.
Okay, and would that DNA profile include the knife that was tested in this case?
Is it okay if I refer to the notes for
Yeah,
all those
please.
samples? So I did take a sample from the blunt end of the handle of the knife, and for that, Franklin Tucker was excluded as a possible was inconclusive. So he failed to demonstrate sufficient statistical support for inclusion or exclusion to that item. For the handle of the knife that I took a sample from, Franklin Tucker was excluded as a contributor to that mixed DNA profile. Let's see. I believe those were the main samples that I took from the item, other than I did take 2 areas from the blade in which I got a complete DNA profile, but that DNA profile had matched the DNA profile from Matthew Bonnet.
And was that a mixed DNA profile as well? Was there somebody else on that blade?
So on area C and D of the blade that I had taken, that was a complete profile. So that was indicative of a single source profile. For the handle of the knife, that demonstrated the presence of a mixture consistent with 3 donors.
Okay, and who were those 3 donors?
So I did comparisons to standards that were submitted in the case. Rory Wilson was included as a possible contributor to the mixed DNA profile, and then I did the likelihood ratio that I mentioned, which is a statistic to do to give weight to that comparison. And the observed mixed DNA profile is 12,000 times more likely to occur if the sample originated from Rory Wilson and 2 unrelated individuals than from 3 unrelated individuals. I then did a comparison to Matthew Bonnet. He was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is 9.9 million times more likely to occur if the sample originated from Matthew Bonnet and 2 unrelated individuals than from 3 unrelated individuals. I did the comparison as well to Paula Belmonte, and she was included as a possible contributor to the mixed DNA profile. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte and 2 unrelated individuals than from 3 unrelated individuals. And then I also did a comparison to John Johnson, and he was excluded as a contributor to the mixed DNA profile.
Okay, and Ms. Oslowski, just in layman's terms, because I love the science behind it, but I'm a little bit more of a layman. Would that mean that it's highly likely that Rory Wilson at some time handled that knife and that it came into contact with both Matthew Bonnet and Miss Paula Belmont?
So since I'm never present, I can never fully say how DNA got on an item, when it got there, or under what circumstances. I can only do the comparison and say if the DNA types could be included as a possible contributor to the mixed sample, and then do a likelihood ratio to that comparison.
Okay, but again, those are the 3 main contributors. I would from what I'm gathering from your report.
Those 3 individuals were included as possible contributors, and then I did the likelihood ratio to get the statistic for it.
Okay, and what about the mask that you tested, the mask that was used?
So for the mask, let me take a look. So I took several areas, several samples from the mask. So an area A of the mask that I called, which was a area that gave chemical indications for the presence of blood. And this was on the exterior bottom right jaw area. The DNA results was a complete DNA profile consistent with a female individual, and that DNA profile matched the DNA profile from Paula Belmonte. And I did a statistic, or the likelihood ratio, to that comparison, and the observed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte than from an unrelated individual. And there was other limited data that was not interpretable that was observed in that sample, but was too limited to do any comparisons to. So that was one area. Then there was another area that gave chemical indications for the presence of blood. I named this area B, and it was on the exterior right side of the forehead. The DNA results obtained from that area demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And then I did comparisons to all the standards that were submitted. Paula Belmonte was included as a possible contributor. I did the likelihood ratio. The observed mixed DNA profile is greater than 700 billion times more likely to occur. The sample originated from Paula Belmonte and 1 unrelated individual, than from 2 unrelated individuals. And then comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate sufficient statistical support for inclusion or inclusion, so therefore it was in that inconclusive zone, so there's no determination can be made regarding the contribution of Franklin Tucker. And then Rory Wilson, John Johnson, and Matthew Bonnet were excluded as contributors to that mixed DNA profile. I then had an area that I called Area C, and this was also an area that gave chemical indications for the presence of blood. And this was the exterior left bottom jaw. The DNA results obtained demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. Matthew Bonnet was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Matthew Bonnet and 1 unrelated individual than from 2 unrelated individuals. And then Paula Belmonte was included as a possible contributor to that mixed DNA profile. The observed mixed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte and 1 unrelated individual than from 2 unrelated individuals. I then compared to Franklin Tucker, Rory Wilson, and John Johnson, and they were excluded as possible contributors to that mixed DNA profile. I then took a sample from the whole interior of the mask, and that demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And I did comparisons to the standards that were submitted, and Rory Wilson was included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Rory Wilson than from 1 unrelated individual than from 2 unrelated individuals. Comparison of the profile from Paula Belmonte to the mixture obtained failed to demonstrate the sufficient statistical support, so it was in that inconclusive range. And therefore no determination could be made regarding the contribution of Paula Belmonte to that item or to that area. And then Franklin Tucker, John Johnson, and Matthew Bonnet were excluded as contributors to that mixed DNA profile.
Ms. Oslowski, again, just if I put it wrong, just please correct me. Now, Area A, C, B, the jury's not quite, I'm sure, we're not looking at the same map right here. Would it be proper to say that Rory Wilson's DNA was the high contributor on the inside of the mask?
So for the inside of the mask, he was included as a possible contributor, and then I was able to do a likelihood ratio to that. And then otherwise, Franklin Tucker, John Johnson, and Matthew Bonnet were excluded as contributors, and Paula Belmonte was failed to demonstrate the sufficient statistical support for inclusion or exclusion.
What was the likelihood of Rory Wilson?
So the observed mixed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Rory Wilson and 1 unrelated individual than from 2 unrelated individuals.
Okay. And then the rest of the ones the rest of the samples that you had were from the outside of the mask, is that correct?
Correct.
Okay, so that would have been a contributing of Paula Belmont and Matthew Bonnet, correct? That were conclusive.
So these were areas that were reddish brown in color and gave chemical indication for the presence of blood. And then for area A, it was a complete female, consistent with a complete female individual, and it matched the DNA profile of Paula Belmonte. And then I did the statistic, the likelihood ratio. And then the area B was a mixture consistent with 2 donors, and Paula Belmonte was included as a possible contributor. And then for area 8C, which was a mixture of 2 donors, Matthew Bonnet was included as a possible contributor, and Paula Belmonte was included as a possible contributor.
Okay, thank you. Now, as far as the inconclusive results, there's a lot of things that can cause inconclusive results. Is that correct?
Correct.
Okay, and again, I've heard of secondary DNA transfer. Can you please explain what that might be?
So secondary DNA transfer is something that would occur. So say that I touch this glass of water, and then the bailiff touched the glass of water, and then we swabbed his hands, and my DNA was on his hands. So we didn't have any direct contact, so it was secondary transfer.
Okay, but that's where that likelihood ratio comes in. Isn't that correct? Where it's more direct, or there's more than enough DNA for the sample.
So honestly, with my DNA results, I can never say how the DNA results got there. I can't say if it got there from primary, secondary transfer. I can only testify to the DNA results that I obtained and then do a comparison.
Would it be more likely if there was more of a sample, say if you had a larger sample as opposed to a smaller one?
It really depends on the sample. And depending on the item. So sometimes it might be a really large item, but there just might not be DNA present. So sometimes DNA just isn't present on an item. Other times there could be DNA results, but it could just be too limited. Or there might be DNA results if there's a biological fluid. Sometimes that DNA result will be more prevalent than other DNA that's present.
Now, the prosecutor also mentioned gloves, how that might affect the DNA results. Now, would gloves totally block the DNA, or would it be the DNA that's on the outside of the gloves that you might pick up, in your opinion?
So wearing gloves, I would expect DNA to not go through the gloves. I wear gloves at my job when I'm doing DNA analysis to try and prevent my DNA getting on an item. But obviously it's difficult to say what DNA might be on the outside of the gloves depending on if an individual touched other things and then touched something else. So it would be difficult to really say.
Right, that would be that secondary DNA transfer would be outside of the gloves, right?
Depending on what they touch or if they touched the outside of the gloves themselves.
Okay. Okay, so again, we go back to those inconclusive results. They can happen for a lot of reasons, and could you explain some of the reasons that might actually happen?
I'm sorry, one more time, did you say
the inconclusive results, why that might happen?
So with the results where I cannot say definitively if they're included or excluded, so obviously it's possible that the DNA just, when doing a comparison to an individual, their DNA might just not be present. And obviously that can be an option, as well as sometimes, as I was saying, there can be DNA that's present, but it could be too limited or not enough to be able to see the DNA types there. And sometimes there can be another high profile that could be overwhelming the sample, preventing other DNA from being present. So those are kind of the three main things that can affect seeing DNA present.
Okay. Again, like if a mixture like that, it becomes hard, and I get it. Let's see, hold on. Was there any DNA from Ms. Bellamont on any other objects besides the mask and the knife that you tested?
Just to look through. So I did have some clothing that was submitted. There was a dark blue long sleeve shirt. And I tested some areas and took some samples forward for DNA analysis. So there was the inside left wrist that I took a sample from, and that demonstrated the presence of a mixture that was consistent with 2 donors, including at least 1 male contributor. And Paula Belmonte was included as a possible contributor to that mixed DNA profile. The observed mixed DNA profile was greater than 700 billion times more likely to occur if the sample originated from Paula Belmonte and one unrelated individual than from two unrelated individuals. I also obtained partial DNA profiles consistent with a female individual from the inside back left forearm as well as the inside front left forearm. And those DNA profiles matched the DNA profile of Paula Belmonte. And the observed DNA profiles were greater than 700 billion times more likely to occur if the samples originated from Paula Belmonte than from an unrelated individual. And then I also had a shirt, another shirt that was from a Roger Roggett. And I had a sample from, let me see. So with items that are collected directly from an individual, I can expect to see their DNA types present. So this item was said to come directly from Roger Roggett. So I was expecting to see his types, and there were two areas, the back middle right and back lower right, and he was expected to be a donor to that item. And then a complete foreign DNA profile consistent with a female donor was obtained from items 17D and 17E, which was the back middle right and back lower right. And that foreign DNA profile matched the DNA profile from Paula Belmonte. And then I did the statistic, and the observed foreign DNA profiles greater than 700 billion times were likely to occur if the samples originated from Paula Belmonte than from an unrelated individual.
Okay, and Ms. Ostrowski, I'm just going to ask you a few more questions just to make sure here. Now, was my DNA, Franklin Tyrone Tucker, just to be clear, was my DNA included in anything in this case? Was it actually, included as nothing inconclusive?
So for the DNA results that I obtained, he was not. There was no samples that he was included as a possible contributor.
Okay, thank you. One other thing. The reason I asked about secondary DNA transfer, how often does that happen airborne? Does it normally have to be something you touch or something you come into contact with?
I'm sorry, can you ask the question one more time?
Can you have airborne DNA transfer, or is it secondary DNA transfer or anything like that?
It's difficult to say. I mean, if someone spits kind of on an item, then that can contribute to DNA being left behind.
I would imagine that could happen. Okay, so if you have something like the knife, right, and you have both victims' DNA on the blade or on that knife, right, now could it be concluded that it's highly likely it was used or came into contact with both people?
So once again, my likelihood ratio or my DNA testing doesn't determine that. I can't determine how that DNA got there. I can tell you that the samples that I took from the blade gave chemical indications for the presence of blood, and then tell you the results I got, and then the comparison to the standards that I obtained.
No, but would it be highly unlikely that the DNA from one individual could go across the room to another?
Mr. Tucker's testifying.
I'm asking a question.
Well, yeah, but it seems like, but go ahead, finish the question.
Anyway, would it be highly unlikely that the DNA from one item could jump across the room and get on the wall?
Judge calls for speculation.
She's an expert.
Well, experts don't get to speculate, but if you are able to answer it, you may.
DNA cannot just move from one item to another.
That's what I was
across
asking.
the room.
Thank you, Ms. Ostrowski.
Okay.
That's exactly what I was asking. Maybe I didn't ask it correctly, but thank you for your time, and thank you for coming out today. I'm done with my thoughts.
Is there any redirect?
Absolutely.
Good afternoon again.
Good afternoon.
Start off with, you indicated or you testified and mentioned the name John Johnson.
Yes.
Was he excluded from DNA on the knife, based on your report, if a refresh your recollection?
Double check. So from the blunt end of the handle, he was the comparison of John Johnson to the mixture obtained failed to demonstrate the sufficient statistical support for inclusion or exclusion for the blunt end of the handle, and then John Johnson was excluded to the DNA results from the handle of the knife, and then the two areas on the blade, as I mentioned, that that matched the DNA profile of Matthew Bonnet.
Okay. Just to recap for the jury, would you please recap for them the items of evidence that the defendant in this case could not be excluded from? They came up inconclusive.
Okay. So for the blunt end of the handle of the knife, the comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate the sufficient statistical support for inclusion or exclusion, so I cannot make any determination to that item or that part of the handle of the knife. Were you asking just about the knife or just all items?
No, and the other items that were inconclusive with respect to this defendant.
Okay, so then area B of the mask that gave chemical indications for the presence of blood, which was the exterior right side of the forehead. The comparison of the profile from Franklin Tucker to that item failed to demonstrate the sufficient statistical support for inclusion or exclusion. And then there was the interior of the mask. Oh, no, excuse me. Let me see. Nope, not that one. He was excluded to the interior of the mask. To the inside left wrist of the first shirt, the dark blue long sleeve shirt that I mentioned. Comparison of the profile from Franklin Tucker to the mixture obtained from item 11C, which is what I called it, the inside left wrist. It failed to demonstrate sufficient statistical support for inclusion or exclusion to that item. And then I also took a sample from the inside right arm, right wrist, left upper arm, lower back, and lower front of that shirt, and comparison of the profile from Franklin Tucker to that mixture obtained, because it actually demonstrated the presence of a mixture with 3 donors. It failed to demonstrate sufficient statistical support for inclusion or exclusion, so no determination could be made regarding the contribution of Franklin Tucker to that item. There was also a pair of black gloves, and from the right hand outside top wrist, I took a sample, and that demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. And the comparison of the profile from Franklin Tucker to the mixture obtained failed to demonstrate sufficient statistical support for inclusion or exclusion, so no determination could be made regarding that item. Then from the left hand inside of a glove, comparison of the profile, that first demonstrated the presence of a mixture consistent with 3 donors, including at least 1 male contributor. And the comparison of the profile from Franklin Tucker to that mixture obtained failed to demonstrate sufficient statistical support for inclusion or exclusion. So no determination can be made regarding the contribution of Franklin Tucker to that item. And I believe that concludes the inconclusive comparisons.
So it's safe to say that there was numerous items of evidence that you didn't have a sufficient DNA sample to compare with Mr. Tucker in this case.
So those are the items that I did get DNA results, but the comparison showed that it was in an inconclusive range. So therefore, no determination can be made regarding if he's included or excluded as a possible contributor to those DNA results.
Okay, and just to make sure you only received 1 mask to analyze in this case, correct?
Correct.
No scarves, no gator scarves or anything like that were ever submitted to the lab, correct?
Correct.
Okay. You testified with respect to, I guess, the level of DNA on the knife with respect to Mr. Wilson. What was that level?
Do you mean the amount of DNA that was actually present?
Yes.
Okay, so. Let me find the sample first. Or do you mean the statistic? I don't know if
The
I got
statistic,
into-
I'm sorry.
Okay, I was gonna say, I don't think I
apologize.
got into the amount of DNA. So from the handle of the knife.
Yes, ma'am.
So that demonstrated the presence of a mixture consistent with 3 donors, and he was, Rory Wilson was included as a possible contributor. And the observed mixed DNA profile was 12,000 times more likely to occur if the sample originated from Rory Wilson and 2 unrelated individuals than if from 3 unrelated individuals.
Okay. Now, Ms. Oslowski, if the defendant in this case is alleged to have been wearing gloves at the time of the murder and the robbery in this case, the likelihood that you would get an inconclusive result is a possibility, correct?
It could be possible. I do know gloves, as I said, can prevent sometimes DNA being left behind. But as I said, I can never fully say how DNA got there, when DNA got there. I can only just testify to the results that I obtained.
Thank you for your time. Appreciate it.
May I recross to ask a couple
You'll
of
have to
questions?
approach the bench here to tell me what the questions would be. If the state would like to join us.
Recross.
Soslowski. Sorry to keep you up. I just need I just wanted to ask 2 quick questions. Do you know how long it was from the time, from the time that the crime, occurred to when you got the first samples of DNA? With a date.
So the offense date was listed as November 17th, 2017. And then I began working some of the items in this case August 14th, 2018.
So we're talking.
And then, let's see, so my report for the first submission of items was released in December 7th, 2018. I don't know if that's easier, maybe.
It's approximately a year. Is that it?
Approximately, yes. And that was all the standards, and the knife, and the mask. And then I had an additional submission of items, and that include the dark blue long sleeve shirt and the gloves that I had mentioned. And that was submitted September 18th of 2019, and then my report was released on March 31st, 2020. I then got another submission of items. The items were submitted on March 18th, 2020 and April 30th, 2020. And my report was June 25th of 2020, and that was the shirt from Roger Rauget, and the buckle swabs represented as being from Roger Rauget as well.
And just one more time, one more question here is, okay, inconclusive means exactly that, right? Can't be excluded, included. It means exactly that, right?
Correct.
Okay, thank you. Oh, and please enjoy your afternoon.
Thank you.
Is there any
No further questions for the witness, Your Honor. She's excused.
Okay.
So my release from it.
Yes, ma'am.
Okay. Thank you.
All right, members of the jury, we're getting near the end of our day here, but I do need to ask you to go in the jury room for a few minutes. I'd like to discuss a few things with the attorneys, and that way I can give you some very clear direction for the future. So please go in the jury room for a few. Thank you. Jurors are gone, so what's on the state's agenda?
Judge, I think we're ready to rest.
You think you're ready to rest, or you're officially resting, or you need a little time to
We are
think?
officially resting.
Okay. Right, so then what does the defense want to do at this particular time?
Well, Your Honor, we'll go ahead and, let's see, tomorrow's Friday. I'm going to go ahead and see if I can get Ms. Paul Belmont, assuming, we are going to file a motion for acquittal, but, assuming that doesn't get it.
Well, file a motion, I mean, that...
I assume it doesn't get approved, but, if it doesn't.
Well, I mean, that would be something that I would be dealing with first thing in the morning. It's...
But could we go in the afternoon?
No, that's not, no, that's not... No, I mean, I can go into
I'm
a
not
lengthy
sure. I'm just not sure. I'm not sure of the process, Your Honor. I'm sorry.
Well, ordinarily, it is a motion that's made verbally without any kind of written motion. It's ordinarily something that is anticipated, and it's ordinarily a function of familiarity with the case, and so it's not. So it wouldn't be something that I would say we're going to put the jury off for the afternoon when it's something we can deal with in the morning, and I don't see any unfairness to expect if you're going to make such a motion. Again, it doesn't have to be in writing. You can certainly gather your thoughts and have plenty of time between now and then to do it. So
that would be fine, Your Honor. The only thing is, at that point, we'll go ahead and I plan on calling Miss Belmont.
Okay, so has all the groundwork been laid for that? Because I assume it's going to be by the Zoom, and I assume that the setup in the I assume she's still in the hospital. I don't know that.
She is still in the hospital, yeah.
And whatever equipment she needs on that end, and whatever address that she needs to hook up here, and whatever additional preparation you've made through our technical team. As always, the devil's in the detail.
Your Honor, the only detail that I don't have control over is the state. They wanted one of their investigators to be present. Ms. Belmont did actually have a request from the state, if they would want to hear it, that she's worked with a few of the investigators at the state attorney's office before. She was comfortable with I think it was Frank.
Zamora?
Frank Zamora and
he's-
Tom Walker. She's comfortable with either one of them. I would ask that the state maybe take that into consideration.
So,
So we'll have one of them, we'll have one of our investigators at the hospital tomorrow morning, Judge. Is she at Lower Keys Medical?
She's Lower Keys Medical.
can we see if Carrie's still here? I don't know that he is or he isn't, but
And did Your Honor get the letter from her physician?
no, I didn't. But I'm not questioning that that the Zoom is all right.
No, it's okay. I was curious because I know she said it was sent in.
Okay, I haven't received, my judicial assistant has not provided any kind of email or fax or otherwise U.S. mail.
I know last time it ended up with the state attorney's office. I'll have to see if that's where it got sent.
But that's not going to be a hang-up for me at this point.
I wasn't able to get in touch with him in his office, Judge.
Okay. So, I'm just concerned that logistically, I don't know.
None of us have been provided with a Zoom link yet. I don't know if that's going to be done tonight. I assume that Your Honor will get a Zoom link and we'll sign in the courtroom, I guess, and have her. We'll be here with the defendant asking questions. She'll be appearing on Zoom. We'll have our investigator over there. It's not my witness. That's all. That's what I'm expecting. And I haven't seen a Zoom link yet. So.
Well, and Your Honor, again, we weren't sure if we were going to end today or end tomorrow. We weren't sure about that. So that, again, it was based on when the prosecution was ended in its case. The only thing I would ask is that for the number or the email of the tech here in the court so that I can arrange it with them.
Let me ask you this. How long would you anticipate her testimony to be?
I actually don't I don't anticipate it to be that long, Your Honor. Again, I don't know what they're going to do on cross, but I mean, her story is fairly simple.
Can you remind me, she testified during the Wilson trial. In what form was that?
That was the perpetuated deposition testimony, and it was a video, I don't know, pretty long video actually, and then the cross-examination obviously was on the video and the redirect, so that was all done through that perpetuated testimony at the Wilson trial.
But it was also for 3 attorneys on the tape, so you guys probably narrowed it down to just the stuff you needed for that trial, correct?
Okay, I understand we can't predict the future. What I'm trying to do is, the best I can, understand what to reasonably expect tomorrow, because what if Ms. Belmonte is 2 hours? Are there other witnesses and things you have standing by? Or?
I do have other witnesses, Your Honor. I've been trying to get in contact with them to tell them, because I actually originally had them slated to run earlier. We've gone a little bit longer, so I've been trying to get in contact with them to make sure that they know that they're supposed to be on deck.
Okay, so I think if we try to put Ms. Belmonte on tomorrow morning, we could run into problems. I don't know, if our tech fellow, I would think he'd be available, if not, certainly one of our other members, but is everything going to go smoothly? Or is it better to, as much as I hate to say this, deal with the JOA motion, deal with the technical stuff regarding any issues about the Zoom, and have the jurors come at 1 o'clock, so presumably at that point in time, everything's in place for that presentation?
So I think that's probably, I'm with you, it's unappealing, but I think I see where Your Honor's thinking. We're going to have the jury sitting waiting for us in the morning while we work all this out.
Yeah.
And I would rather not have that.
Yeah, I'm just, again, trying to be cautious and considerate of those folks. So we come in and I find out our main guy isn't here, we get someone else. Well, what kind of Zoom address? How's that equipment working? Have we tested it?
I would agree, Your Honor.
It's just better to have that cushion.
Understood, Judge. Just so Your Honor's aware, Judge, as far as the Zoom link, because I have the Zoom application on my phone. If Mr. Tucker or his representatives have that link or that application, they simply send the state an invitation. We can log on here via the court's internet system and join that meeting, but there are certain steps that need to be taken on Mr. Tucker's part at the hospital to get that in the way.
Well, I mean, I like your knowledge and your, your level of understanding. It just, in my experience, things go wrong. Stuff happens. So
Technology.
What I say is I'm going to tell the jurors, come back at 1 o'clock. I'm going to tell us to be here at 9. I'm going to hear Mr. Tucker's motion for judgment acquittal. I'm going to then see if we can, whatever logistics, whatever coordination needs to be done to be sure that the testimony of Ms. Belmonte is as smooth as possible in terms of the presentation, the communication, and then if you can have someone else available after her, fine. Other than that, I guess you'll have the weekend to line up whatever else you anticipate, but we can deal with that tomorrow. So that's the plan. Anybody have any questions?
No, Your Honor.
No, Your Honor. Thank you.
Oh, that's a good question. Are you going to rest in front of the jury?
We'll go ahead and do that right now, sir.
All right. Very good.
All jurors present in the courtroom, Your Honor.
Thank you. Welcome back. Please be seated, everyone. All right, welcome back. Mr. Mansfield, on behalf of the state of Florida.
Yes, Judge. At this time, the state of Florida rests its case. We've presented everything we intend to present.
All right, members of the jury, the state has now rested its case in chief. So that's a point in the trial where the judge has to conduct some proceedings outside of your presence. Again, this is normal. That's the way trials go. You can see what time it is, so it seems to me that it's a good time to excuse you until 1 p.m. tomorrow. We'll take care of what we need to take care of, which is not short. And when you come here tomorrow, the defendant will have an opportunity to present evidence in his case. Once again, I want to reassure you that we're on schedule. We're big picture, we're on schedule, and so we all thank you for your flexibility, your attention, your patience, your understanding, and your participation as jurors in this case. Remember, follow the cautionary instructions. See you tomorrow at 1. Thank you. One more thing, Mr. Tucker.
Yes, sir.
I really don't want to go through the empty chair tomorrow
made yourself
morning.
clear.
Would you like to start at 9:15 tomorrow so you can factor in the traffic and all the other?
Well, Your Honor, whenever Your Honor is.
Well, I understand that. Like I said, I really don't want to have to
I will do
deal
everything.
with that issue or unpleasantries. So if I give you an extra 15 minutes, that ought to assure your punctuality.
Yes, sir. And like I said, I apologize. It's just,
I know, I
but
understand.
I will actually do every effort to make sure I am here early, Your Honor.
Okay, so we'll say 9:15, and then whatever, in terms of setting up this Zoom testimony, let's kind of anticipate it. And we'll hear the motion for judgment of acquittal, and we'll go from there. So have a good evening.
Thank you, Your Honor.
9:15.
you.